May I please, your lordship? Lordship, the matter relates to pension, lordship. The
Want it for listing,
listing, lordship.
admission.
Admission, lordship. On 24th, lordship.
24th, we can't say. Let it be in the month of February. 1st of February, 2nd of February,
Lordship.
2nd of
Lordship.
February.
I'll always.
May please, your lordship. So I beg to mention 4 analogous matters for listing that is pertaining to bench 5, lordship. Can it be on this Monday, 11th?
Monday. 20. Which Monday you want?
11th.
11? 11th of February.
Lordship.
February.
Lordship, can it be on 23rd? 23rd of this month?
All right.
Tuesday.
23rd.
Yes, yes, yes.
23rd. Yes.
My lord, this is the matter. I am all mother of my deceased son. Every pensioner benefit has been taken by my daughter-in-law. So I want a share from that. So there is a notice, and court asked me to file affidavit regarding my sources of income. I have filed. It may kindly be listed on 22.
No date is fixed.
No,
No
that
date,
is
no
fixed.
date fixed.
22-1 we have paid.
Let it be on 24th.
24.
24th. Yes.
Lordship, I beg to mention series item number 18 to 28. Lordship, same issues are pending before the Supreme Court, Lordship.
Before the Supreme Court.
Yes.
Lordship.
I'm for
No,
the
we
respondent
heard something yesterday, last occasion,
No, the matter is
The
yet to
case-
be disposed of, you know.
or yet to be disposed of.
Yes.
What is the issue about?
It's the imposition of central excise upon the coal value, you know, sir.
Imposition of?
Central excise upon the coal value. They are the traders of Coal India.
Hmm. This is pre-GST.
Yes. Time for the respondents.
So why not close it? Whatever the Supreme Court decides will be binding. Why keep it pending?
Oh,
Why keep it pending?
There are certain law points to be decided. Because in the
Whatever law points are there will be decided by the apex court.
then you're not today not possible because some other day then
Other date,
Let it come up. Let it come up. 2014 matters.
2014.
12 matters. 13 matters.
Yes.
Lordship,
Today
Let the matter be called up. Be around. Yes. Yes. This WPC 3834, first item, I think,
My lord. My lord.
that you have challenged the order of the Registrar General, Inspector General,
My lord, the suspension order, madam.
Inspector General.
As they are.
Now, this is to be placed before a permanent committee. What is the status here?
My lord. Yes, sir. My lord, on the last occasion, my lord, my lordship was pleased to hear the matter.
No, we are asking you a question, page number 52 of
Fine.
your first writ petition, which is WPC 3834.
Yes, yes, my lord.
This is the order suspending.
Yes, my lord. Correct, my lord.
This was issued in 23,
My lord, matter will be placed before the permanent.
permanent committee. Now, what has happened after that?
No, my lord, I do not have the information. My respective.
What
chairman
is
may
a
have-
permanent committee? Why has it been placed before the permanent committee?
this we have to take.
This appears to be some kind of an interim order.
Personal arrangement, my lord.
It is for the permanent committee to decide.
Possibly. In fact, your lordship was hearing the other matter on the last occasion.
No, we were just going through.
Well,
So we find out that this writ petition, the other matter is issued by the DC.
Yes,
Now, assuming the permanent committee decides either way,
my lord.
that will have an effect on the order passed by the DC. Mr. Bhuya,
My lord, my lord.
if the permanent committee decides,
Yes, yes, my lord.
it will have an effect on the subsequent matter also.
My lord, the subsequent, yes, my lord, because this is a follow-up action
That's right.
regarding the, my lord, the proceeding initiated by the DC and culminated into the suspension order.
Correct.
And now, my lord, the issue is that whether, my lord, the action which is they have initiated, I have raised, my lord, some legal issues, my lord.
The reason why we are asking you
My-
is because you are not putting to challenge these provisions.
No, my lord.
The challenge is not to the virus.
No, virus, I am not required, my lord, because
Exact-
the challenge which I have, my lord, with my limited understanding, what I respectfully beg to submit, my lord, the challenge which I have made, my lord, is the duty which I have been assigned with statutory prescription, my lord, which I have discharging my duties. Now they have said that I cannot discharge their duties in view of the provision of the Child Marriage Prohibition Act 2006. My lord, on the last occasion, I have made a submission, my lord, the Child Marriage Prohibition Act has not been, my lord, till date, it has not been enforced by of a notification. On that day, my lord, my lordship was pleased to ask for from my respected senior that whether such notification had been issued or not. If the notification is issued, my lord, then the case is required to be, my
Next
lord,
Monday,
proceeded in a different manner. If not issued, my lord, then they cannot enforce that law, my lord.
Yes, Mr. Mazumdar.
My lord will give me some time. Can you give me a week's time? Next Monday when I'll produce it. Possibly in the second lead petition there is 3834.
My lord.
In fact,
3834.
34,
My-
the order impugned says that again as per provisions of Rule 8 of Assam Muslim Marriage and Divorce Registration Rules 1935, when possible, the matter will be placed before the permanent committee. Whether this permanent committee consists or not, it has to be ascertained. Because in terms of Rule 8, my lord, it says when possible, he will consult the permanent committee. Possibly, I'll have to take this part.
No, the order itself is very clear.
My lord.
My lord.
It shall be placed before the permanent committee.
Yes, yes,
So perhaps it must have been done in the meantime.
my lord. I'll have to find out.
And my lord, that order is also required, that notification. The Child Marriage Prohibition Act 2006.
That
Section-
notification,
my-
you find out whether it has been
I don't
done.
know.
Because
When can you get it?
week's time, my lord, would be okay.
Then let us have it on first.
First of February, my lord.
6th of February.
My lord.
6th of February.
That's fine, my lord.
At the request of Mr. D. MSS Sharma, learned Government Advocate, assisting Mr. D. Mazumdar, learned additional AG, matter stands deferred till 6th of February to complete their instructions on the queries put by the court, namely whether the suspension order in terms issued by the Inspector
IGR.
General
Registration.
of Registration impugned in WPC
3834.
3834 of 2023 was placed before the permanent committee, and if so, what orders have been passed, if any orders have been passed. And secondly, whether any notification has been issued by the state
My lord.
for implementing the Child
Child
Marriage
Marriage Prohibition Act
Prohibition
2006 in the state of Assam.
in the state of Assam.
My lord.
Let these instructions be placed before the court. The next date fixed. List on 6th. Mr. A.R. Bhuya appears for the petitioner.
My lord.
Yes, 6th.
My lord. Obliged. Number 3.
Cooperation, yes.
Also, I have received the instruction The thing is that, your lordship, the name of the petitioner has not been included in the provincialization list, your lordship. And in place of the present petitioner, the another name with the,
You give us some material, or you place some material that the other person who you department claims is not the petitioner
yes, sir.
was a person, it was indeed a different person,
Right.
and it is supported by some evidence from the department to show, let us
That
say,
both
the
are- both are
payment of
different person.
payment of salary.
Lordship. But otherwise, lordship, the latest instruction which I have received, the Registrar of Cooperative Societies has written a letter to the Joint Secretary to provincialize the present petitioner, your lordship. Because without provincializing the petitioner, the pension papers could not be processed, your lordship.
Okay. So where is that letter?
Lordship, I have.
It is hardly legible.
Lordship may take up my copy, your lordship. So lordship kindly takes the last paragraph, your lordship.
Now, by virtue of this letter, it means that he was an employee.
Lordship, yes, sir. Because he served in the department and he got retired, your lordship.
Yes. Have you seen this letter?
Lordship, I do not understand as to how Lordship, the authority paid all the benefits, Lordship, till the date of my retirement of a provincialized employee, Lordship.
That is what we are asking you. You show us any evidence that you have released salary to this Hamid gentleman who you claim is not the petitioner.
Right.
You produce some records.
Lordship.
That will shorten the entire issue.
Lordship. And then let the matter be fixed after a week, your lordship. I'll get this.
Let him produce.
Lordship.
You also produce your particulars with regard to the bank details in which you have received the salary
Lordship.
to find out whether it is the same person or not.
Lordship.
Mr. G. Bordoloi, Learned Standing Counsel, Cooperation Department, submits on instructions that the Registrar of Cooperative Societies has now placed the necessary papers before the Secretary Government of Assam Cooperation Department, requesting for taking necessary steps for provincialization of the services of the petitioner in the rank of junior inspector / auditor of cooperative societies with retrospective effect. Stop. Mr. Talukdar, Learned Counsel for the petitioner, submits that if the petitioner was never regularized or provincialized, then if the petitioner was never provincialized, then the benefit of all financial benefits could not have been released to the petitioner as was done. He therefore submits that the petitioner was regularized and his name appeared in the list of persons not regularized, provincialized, and his name appeared in the list in the notification dated 5/1/2006. And therefore, the contention of the petitioner respondents are not correct. Accordingly, in view of the contesting submissions made by the learned counsels for the parties, the respondents are directed to place before the court materials to show materials to support their contention that that Abdul Hamid, whose name appeared in the notification dated 5/1,
2006, your lordship, serial number
2006,
436.
at serial number 436, is not the petitioner and some other person. Mr. Bordoloi submits that you'd like to complete his instructions and place this information before the court on the next date fixed. He prays for 2 weeks further time. Let the matter be listed again on 6th of February.
Obliged, Lord.
Obliged.
Mr. J.K. Goswami appears for the state. Yes. Yes.
Lordship may kindly peruse two orders last, 22/6/23 and 10/8/2023. Petitioner father died as a master lorca, regular master lorca, but pension has not been given. I am for due admissible benefit.
Yes, Mr. Dhar.
Our last occasion, Mr. Nayak had taken time.
Pleadings are complete.
Yes, ma'am. Pleadings are complete.
So what is your stand?
My lord, if I go by the affidavit, he was regularized in 84,
Hmm.
1/3/1984, my lord. My affidavit, page 27, para 5. At that time, the total length of service and daily wage was 21 years, 5 months, 27 days. So, my lord, if we go by,
Hmm.
আমি তো মুখ করেছিল ইনসিডেন্ট ওটা কোন করেছিল আপনার কি টেনশন
The affidavit, there's a categorical averment that he was regularized. His name was wrongly reflected.
daily wage never
He completed 5 years, 5 months of regular service. Otherwise, he has completed 21 years.
My lord, that was actually 27 years round. I have filed my reply also.
Whatever, what is the service required for pension? Mr. Dhar?
my lord proportion 20 years
So he's more than
Master-
20,
master of
21 or
20
25, it is more than 20.
it is 21 years my lord
All
If
right,
you go by-
21 years, we'll go
still-
by your
still-
statement.
still my lord if 21 years again
Ah,
so he is entitled
he is entitled.
because my lord he masteral worker if you go by
So therefore, Sanjita Roy.
yeah 2019 2 GLT 805 that is Sanjita Roy if you go by the 20 years whatever the amount my lord that AG has to calculate they will do the needful আমি তো লিখিব না ও নাই নাই এই তাকে করাই নাই না তার কারণে দিয়া লাগতে
Okay. Anything to submit?
my lord
AG?
And my lord, they have
regularized, my lord. We have to learn.
regularize and Sanjita will cover my lord 21 years so there's no point harping on this
Yes.
And my lord, they have stated that an amount of rupees 4,485 of gratuity has been paid, but I have denied, my lord. They have not enclosed any documents regarding the payment. I have denied.
Whatever-
my
whatever
gratuity amount
amounts-
was not paid.
Whatever amounts are there,
But they have stated without annexing any documents that they have already paid my gratuity amount.
very well, you take it up with the authorities. If at the final payment it is not released. Okay, heard disposed.
My lord, my gratuity amount should be
My lord,
considered, my lord.
that we
That's
have paid, my lord, we have said, if there is any issue, my lord, he has to,
Whatever amount he is entitled to, you'll pay
lordship, whatever he received.
after
Lordship,
deduction of any amount which may have been released.
Lordship, whatever he received, lordship, that may be adjusted in.
Exactly.
Lordship.
Yes.
My lord, I have not received anything, my lord.
We'll record your submissions
Department will
also.
verify,
They'll
madam.
verify
Yes,
and
ma'am.
then pass
Yes.
necessary orders on.
And I am categorically stated that I have not received my gratuity amount also.
What do you want now? What do you want?
Everything has to be verified.
We have allowed your writ petition. Anything more you want?
That is, I had also a prayer, my lord, regarding interest, my lord, as per section
Interest.
190.
That will be different prayer, my lord.
All right, interest, hard interest, reject, denied. Interest is denied. Sangita Roy. Take out digit.
Only my
Other
lord,
than-
Sangita Roy,
give-
he is good.
Get up. Yes, disposed. Hard Mr. Bora. D. Bora, Mr. Ardhor for PWD, Mr. Talukdar
For
for
seven, my lord, as per as seven.
respondent 7. Anyone else? All right, disposed.
May I please, your lordship? I'm appearing for the respondent corporation.
May it please your lordship.
Their pension seems to have been released.
My lord, the petitioner is an engineer in NIPCO. He retired on 28 February 2017. Also, so far as salary is concerned, lordship, it is determined by the board in their meeting and as per guidelines issued by Ministry of Power, Government of India. Accordingly, a revision was brought in and the petitioner was also entitled to it. Lordship may kindly come to page 16, Annex A. There the order is there, office order number 151. So the petitioner comes under grade E9 at the bottom. Lordship. But he was entitled only for 2 months because he was brought into force on 1st of January 2017 and he retired on 28th of February 2017. He was entitled for 2 months benefit only, but that was denied to him and he made several representations.
Mr. Chaudhary, there is an affidavit filed on behalf of respondent 1 to 4. In paragraph 5 and 6, they say that an amount of rupees 18 lakhs have been released.
Lordship, before that, if your lordship kindly look at paragraph 4, they say that the statements made in paragraph 2 to 14
Are admitted.
are admitted. So lots of allegations are from the side of the petitioner. They have not answered to it. And so far the contents of the paragraph 5 is concerned, I was never issued any notice. I was not given any information regarding any complaint lodged against me for the first time.
No,
in a
no, no, no. The question is whether that 18 lakhs you have received or not.
Lordship,
18 lakhs.
18 lakh.
Have you received it?
That I have received, Lordship.
So they have released that amount after deduction of certain amount
Lordship,
pursuant to some inquiry.
lordship.
So that inquiry part,
Ah,
it is my grievance, Lordship.
that's right.
Because behind my back,
You are required to put him to notice before deduction.
Lordship.
Why was it not done?
Lordship, then I'll have to obtain instructions in this.
What instructions are necessary? Your statement is that recovery for 21 days equivalent leave salary was made
My lord,
pursuant to some inquiry. of the Vigilance Department, which was approved by the competent authority. Now, what is that inquiry? What was the recommendation?
Even that was, I'm afraid, Lordship, it's not there.
That's
When I
right.
get some time, I'll obtain it, my lord.
It should have been there in the affidavit, which was
Lordship.
filed 3 years back. Let him obtain the instructions, Mr. Chaudhary.
Let the date be fixed for that.
Yes. Mr. A. Sharma, learned counsel appearing for NEPCO
NIPCO, Lordship, respondents 1 to 4.
1 to 4 submits that he'd like to complete his instructions with regard to the vigilance inquiry which was instituted against the petitioner and on the recommendation of which 21 days equivalent leave salary was recovered from the remaining dues, and as to whether any notice on the petitioner was served
Lordship.
by the department. So, Mr. C. Chaudhary, learned senior counsel, assisted by MS J.S. Das, learned counsel for the petitioner, submits that the grievance of the petitioner is that no notice was, petitioner was not put to any notice prior to recovery of 21 days equivalent leave salary pursuant to any vigilance inquiry instituted. Stop. There was no notice issued to the petitioner by the vigilance department also prior to the inquiry or after conclusion thereof. In that view of the matter, and in view of the prayer made by the learned counsel for the respondent, matter stands deferred to be listed again on how much time do you require?
Lordship, it will come from Shillong, at least 4 weeks' time, my lord.
Let it be on 15th of February
15th, my lord.
or 20th of February, 20,
Lordship.
20 February.
Obliged.
Obliged, my lord.
Regarding the Vigilance method, I don't know what there shall be some time frame method.
Of course, of course.
Either 3 or
Of
4.
course, of course. We'll give a time.
Obliged.
Yes.
My lord, the matter relates to non-payment of family pension. But now, my lord, as it has transpired, there are some movements. There is an affidavit filed by respondent number 6 and 7, which says that pension from their end will be activated. And today, my senior friend is perhaps with this instruction.
I have passed on the instruction, Lordship, the PPO has been issued, Lordship. in
Oh.
favor of the petitioner, Lordship. I'll give you. I'll give it. For now, you can.
Okay, for now.
My lord, in this case, we have filed an affidavit on 11/1, that is not on record. I think that must be on record.
You will get it on record, but in view of this PPO, is there anything
My lord,
further?
that's why, my lord, affidavit filed by response 6 and 7, and the instruction now placed by respondent number 1, 2, and 11. Now, this goes to shape, indicate that pension now has been activated. But
Mhm.
my lord, so far payment is concerned, that as it transpires will be from the month of February. So let the affidavit come, my lord, let it be sometime in the second week of February. By then, hopefully, my lord, even the payment also will be made. This honorable court, my lord, will be able to monitor that aspect as
We
well.
are not supposed to monitor.
That is there, but my
We,
lord,
you are prayed for release of the pension, they have issued the
They
PPO.
have
Now,
issued-
in view of the PPO, we'll record the submissions,
my lord, that can.
close it. If they
That's-
don't, you
Ah,
have
that can
remedies
be
in
done.
law.
That can also
Why is
be
the question of
done. That can
monitoring?
be- Now, since my lord, my senior friend.
That
is
will get it.
Well,
In view of this, we
Yes,
don't need to further adjudicate on
that
this
can
issue.
be done. Because now it seems the grievance, my lord, that was there, that has already been addressed.
That's right. Yes, we'll get your affidavit on record, but in view of this PPO, There's nothing further to adjudicate.
Not seen that PPO, my lord.
You don't have to see, they've admitted that the PPO has been issued. Petitioner has agreed that it is a PPO.
PPO under the central.
That is under the CCS. My lord, the PPO that is now placed,
But our pension will be paid to them. That is the.
there are two authorities. My lord.
That's the
My,
problem.
my other senior friend actually is referring to pension that will be paid under the employees pension scheme. They say that has been activated, that is by UFN affidavit. And today, my lord, my other senior friend places this instruction that is as per the CCS rule. That is Central Civil Services Pensions rules. Even under that scheme also, the petitioner is entitled to family pension. So according to them, that is also activated and that will be.
Lordship, since it is already admitted, Lordship,
If
do
both
not
are paid, I have no objection, my lord. We'll keep on paying under the employees provident fund.
Is she entitled to pension from both?
But under the EPF scheme, he is entitled because it is his own contribution.
Then
It is his own contribution. We cannot
That-
stop it. We cannot stop it. That is the problem.
your prayer is under payment of pension under CCS pension rules.
Yes, because my lord, the pension under EPF that was being paid, that was stopped only for an arrangement to be paid under CCS. But CCS was also not paid. That's why we were before this honorable court. Now EPF authority has filed an affidavit saying that pension under EPF also will be paid. It cannot be stopped since it was the contribution of the deceased. So to that.
Very well, we'll record it.
Yes, yes.
Heard learned counsels for the parties. This writ petition is filed by the petitioner whose late husband expired while serving as senior attendant within bracket aeronautical at the Silchar Airport, Kumbigram, Kachar, Assam. Initially, the petitioner received family pension under the Employees Pension Scheme 1995, which was sanctioned by the Airport Authority. Stop. Subsequently, a new PPO was issued to the petitioner, providing that she is now entitled to the enhanced rate of pension of rupees 9910 under the CCS pension rules. Stop. Thereafter, the EPF pension which was received by the petitioner and which was being paid by under the Airport Authority of India was stopped with effect from 1/3/2021. In view of the fact that the petitioner is now will be entitled to receive pension at an enhanced rate of 9910 under the CCS pension rules. Stop. The petitioner represented before the authorities requesting for release of the pension at the enhanced rate in terms of the communications issued. Stop. There was some recovery made, sought to be made.
Sought to be made. That has not been.
In response to that representation, by communication dated 28/3/2022, issued by the respondent number 7, namely the Assistant Provident Fund Commissioner Pension. The amount which was already paid to the petitioner towards pension for the period 1/3/2021 to 28/3/2022 was sought to be recovered. Stop. The petitioner thereafter submitted representations before the competent authority. For release of the enhanced rate of pension as communicated. Enhanced rate of pension under CCS pension rules as communicated earlier. Stop. However, since the pension payable to the petitioner was not released, the petitioner has approached his court, filing this writ petition, praying for a direction to the respondents for release of pension under CCS pension rules and any other such further orders as may be required. Stop. In response to the writ petition, an affidavit has been filed on behalf of respondents 4, 5, 8, and 9, which is the airport authority.
Well,
The airport authority in their affidavit has made an averment that the petitioner was one of the one such employee who was absorbed en masse into the airport authority, and he was not eligible for government pension being rendered, having put in less than 10 years of service in the civil aviation department earlier. Stop. That apart, the late husband of the petitioner exercised the option for CCS pension on 28/12/2017. Para.
2000.
Union has not filed an affidavit.
One of the
Lordship.
petitioner exercised the wife.
the wife exercise.
Wife exercised. No, but sorry, wife of the petitioner. The petitioner exercised the option of CCS pension, not the petitioner's husband. Para. Notices in the matters were issued, and today when the matter is called up, Mr. R.K. Dev Chaudhary, you are representing
1, 2, 3, and 11.
1, 2, 3, and 11 has placed before the court a communication issued by the senior accounts officer of the Regional Pay and Account Service, Government of India, Ministry of Civil Aviation, forwarding the PPO bearing number so and so, number to side हुए थे. Stop. Mr. Dev Chaudhary submits that in view of the PPO being issued, the petitioner is now will be entitled to the family pension at the enhanced rate of 9910 with effect from 1/1/2024. Stop.
May I just point out, Lordship, if your Lordship will see 16,
Hmm.
point number 16 on the second page,
Hmm.
below,
Yes,
area pension from 89
will be paid.
will be paid, Lordship.
It is further mentioned that the arrear pension with effect from 18/9/2009 to 31/12/2023 will also be paid by the said office. Para. In view of the PPO having now been issued, and the submissions of the learned council representing the regional, what is that, account service.
Yes, Lordship.
Your-
Regional pay and accounts.
Regional pay and account service, that the pension will be released now in view of the PPO having been forwarded to the competent authority to be released to be sent to the petitioner. Stop. We don't find any further orders are necessary in this writ petition. Taking in record the submissions made by the learned council appearing for the regional pay and accounts office. That the PPO has already been released and the particulars of the pension to be released along with the arrear having been mentioned in the communication enclosed under the cover of the letter dated 9/1/2024, bearing number so and so, comma, the writ petition stands closed, directing the respondents to take all effective steps to proceed for release of the pension in terms of the PPO number so and so issued to the writ petitioner. In that view of the matter, the writ petition stands closed with the above directions. That's all.
Well, the submission of the EPF authority will not be necessary. The affidavit that was filed by the
Lordship has
EPF.
recorded.
We have recorded
No,
an affidavit.
By the.
No, that is, no, that my lord
It is there.
Yes, no, that is not on record.
It is not on record.
Another affidavit.
Yes,
Yes,
that is by
filed
sixth and seventh,
sixth and seventh. That is not on record.
where they have also accepted.
You have a
that-
copy.
Yes, yes.
You have a copy.
I have got.
You give us a copy. You have filed it. When did you file it?
On 11th of January.
In,
এই affidavit to বিচাৰে পেলাই লৈ আহিব। Dev Chaudhary submission or আগত লিখিব is further submitted by the learned counsel appearing for the respondent 6 and 7 that an affidavit has been filed on, there's no date here,
11th of January.
11th of January, wherein they have stated that the pension payable to the petitioner under the EPS scheme, EP
Yes.
scheme,
Employees pension scheme,
employees pension scheme
1990.
will also be continued to be paid. Which paragraph?
page number, my lord, 50, paragraph number F. This will perhaps cover everything. They have admitted that she will be entitled to EPF, but not by cancellation of CCs. Page 50, paragraph F.
Para 6 also we say.
It is, there is a categorical averment in the affidavit that the benefit of pension under EPF Pension Scheme 1995 being a statutory benefit, this benefit cannot be cancelled or annulled to provide any other benefit in substitution thereof. In that view of the matter, the petition stands. Huh? Yes, disposed.
DPO.
Copy to my.
Please, your lordship. Lordship, can the matters be taken at the end of the list?
Yes, yes. Tejpur.
Lords.
Yes. What is your instruction?
I received a letter, my lord. If you objection, my lord, from the Audit.
Objection has been raised. You have given a clarification now. Why are you not releasing it? Further objection.
No, my lord, no, but from, we meet up the objection, my lord, but from you, account, controller, my lord, we have not get any reply, my lord. So lordship may direct both the authorities to, my lord, to grant them.
Where is that report? Oh, inspection report 1819.
No, no, petition, my lord.
Your lordship will get it at page 27.
Hmm. Where is that objection?
Lordship. Your lordship will get it at page 31.
Hmm?
Now you have furnished the reply.
Reply here.
Page number 33.
No.
After everything, they say that this was brought to the notice of the university by audit query number so and so. However, the reply to the query has not been received. Now you have furnished the reply.
Page 43, your lordship.
recover.
Who represents the Director General Audit?
I've received the instruction.
What does it say?
Lordship, as per my instruction, Lordship, the para has been settled, my lord.
Huh?
Para is settled, my lord. They have given us one letter, my lord, that as recovery has already been completed, the para may be treated as settled. And in terms of that, Lordship, we have there are minutes of meeting, Lordship. I have received the instruction.
Also, they have treated that recovery has been made.
They already made, Lordship. Nothing, Lordship. That
What is the view in respect of the reply given by the
yes,
university?
Lordship.
No, is there any opinion or recommendation expressed?
No, Lordship. No, nothing, Lordship.
No recovery has been made.
It has been put on hold.
Hold, your lordship. And ultimately, I am against that, your lordship. They cannot, your lordship.
They have already
Have you
recovered
filed your counter affidavit?
Lordship, I have filed.
No, see, the question here is that the fact that he was not qualified was known to the university. University wanted somebody. They had no other option. So it is under these circumstances that he was appointed.
Appointed, my lord.
And he has no contribution to that.
Yes, my lord. That is also. Yes, yes.
So therefore, for something which cannot be attributed to him to be his fault,
Yes, my lord.
why his pay should be withheld?
Lordship.
What is your response to that?
That is all. Paragraph 5 of my affidavit, Lordship. Page 58, my lord.
Paragraph?
Paragraph 5 of my affidavit in opposition, my lord.
Paragraph 5.
Page 58.
Hmm. Yes.
And in terms of that, Lordship, no reply was given by the university till the time of ending of the audit, Lordship. That is our affidavit in stand, Lordship.
No, but now you have already got
Lordship.
it. But
Now they have given
your
that-
view has not changed.
Yes,
In
Lordship.
spite of the reply,
Lordship.
the recommendation has not changed, has
Lordship.
not been altered.
Lordship. And subsequently, Lordship, they have informed Lordship that with the approval of the competent authority, that said withheld amount has recovered and transferred to so and so, so and so. As the recovery has already been completed, that para may be treated as settled. And thereafter, Lordship, we have there is minutes of meeting, Lordship. We have para has been settled, Lordship. But in respect
And you
of
are
dropping
relying
of-
on Rafiq Mashi.
Lords, Rafik Nasi is very clear, your lord.
dropping of para, Lordship, there is no clarification, Lord. Lordship,
Rafik Masi, your lordship, is very clear, your lordship. It says even para 18(4), your lordship. Recovery in cases where an employee has wrongfully been required to discharge duties of a higher post and has been paid accordingly, even though he should have rightfully been required to work against an inferior post. That is one. And secondly, your lordship, recovery from the retired employees or the employees who are due to retire within 1 year of the order of recovery. Now here, your lordship, both these
So
conditions.
these are pertaining to grade 3 and 4 posts.
No, your lordship. Your lordship will 18(4), the first, it says recovery from employees belonging to class 3 and class 4 service group C and D, your lordship, number 1. And number 2, your lordship, recovery from the retired employees, your lordship.
Hey, Rafiq Mashi, yes, thank you.
group P होगा. Group P.
So far as group C and D or 3 and 4 is concerned, absolute bar. So far as others are concerned, Your Lordship, more within 1 year, Your Lordship, of his date of superannuation, Your Lordship, it is barred. And here is a case, Your
Very good. If you have an extra copy, you can furnish.
Lordship, I have provided one copy, Your Lordship,
Not here.
last occasion. It's 2015 4 SCC, Your Lordship.
हाँ.
334.
Copy निकालो.
2015 4 SCC 334.
Okay, we'll take it up after some time.
No. No.
Or maybe at 2 o'clock.
Lordship.
At 2.
Lordship, our minutes of meeting, Lordship, on the basis of reply furnished by the Tezpur University, the so-and-so proposed to drop, Lordship, that already dropped, Lordship. Information is there, Lordship. That para has been dropped, my Lord.
That you say you have pointed out to the reply.
Lordship, one copy, Lordship, para settled, but last portion, Lordship, one line is there.
Where is that? This is not a part of the affidavit.
Lordship, no.
Why don't you bring all these in?
Lordship, prior to,
proper format?
after filing of the petition, Lordship, I have got the instruction, Lordship, in terms of last order, my Lord.
No, is it dropped because of the reply or is it dropped because the amount
After,
it had?
after getting the reply from the university, my Lord. Clarification, that page 43 of the petition, my Lord. Last page, my Lord. And
Last page.
yes, my Lord. Last line, my Lord.
You're referring to this bunch of papers. Irregular appointment. It says para settle.
Yes, para settled, but last portion, decision is Lordship, para has been dropped, my Lord.
Where is the decision?
Except 31 serial number, last page, my Lord.
Last page.
Last page, last line, my Lord.
31.
Yes,
Discrepancies to the fund
last line, my Lord, of that.
paid by Tezpur University to KV. Kendriya Vidyalaya.
No, Lordship, last line of that instruction, Lord.
Okay. It says 17 drop or settle 17 paras.
Yes, flag mark is 11, Lordship. Respect of 11, Lordship, is that.
No. It says in view of on the basis of the replies, audit proposed to drop or settle 17 paras.
Yes,
Which are the 17 paras?
that is also, Lordship. I have flag mark, Lordship.
No, you properly do it.
Lordship.
Do it. Bring it at 2 o'clock. We'll see.
Lordship.
Ready for Duta was that good. Come back at 2.
Lordship.
Yes, contempt.
In this case, the appeal is listed for hearing on 24th. And so far as the review is concerned, hearing was completed just before the Bihu vacation. It is fixed tomorrow, Lordship.
Yes.
Yes, my lord.
As submitted by Mr. D. Saikia, Senior Counsel, Learned Advocate General for the State, assisted by Mr. D. Nath, Senior Government Advocate. That
Let it come after in the second week of February because their senior counsel will not be present.
connected contempt appeal Contempt appeal.
Contempt appeal is, it is fixed on 24.
Do you have the number?
Yes, yes.
Two of 2020,
Contempt appeal 2 of 24,
23.
23. Is fixed on
24th of January.
24th of January. And that apart, a review filed against the order in which the contempt proceedings has been initiated was already heard and is listed tomorrow,
Tomorrow.
i.e. 19/1/2024 for orders. In that view of the matter stands deferred to be listed on
10th of February.
10th of February.
10th of February. 10th of February.
Yes, Lordship. Because I am sure on 24th it may not happen.
No,
because
no, no.
the senior
10th of February is a Saturday.
Oh, I'm sorry, Lordship.
9th.
Let it be on 9th.
9th of February.
9th of February.
My lord,
Mr. J. Patwari appears for the respondent.
no, I am for the petitioner here.
For the petitioner. Okay.
Therefore, my humble prayer is, my lord, as regards the personal appearance of the contempt respondent, the last order of your lordship dated 8/1/2024 will hold the field.
No, sorry, I didn't get you.
My lord, there was a personal appearance of the respondent.
Which has been dispensed with?
dispensed with on 8/1/2024,
Ah.
and there is a rider attached to that, and
Ah.
that will hold the field.
That will, we don't need to reiterate it. It is there. If you require, we can call him. Even if it is not there, we can call him.
Right.
Is there any bar?
No, but
No.
Highly obliged.
deeply.
Subject to, of course, the guidelines,
Yes, ma'am.
Recent guidelines.
recent guidelines.
Please, Your Lordship.
Dismissed.
No, no,
Is
no.
infractuous?
No, it's a good case.
No.
But in this case, we are also not resisting. Only thing this case may be allowed and we will proceed with the fixation of quota amount.
No, no. Their case is that the quota which was fixed,
Should be enhanced.
it was enhanced, but the direct recruitment
So direct.
did not follow that ratio. That is the issue.
Directed to proceed us within the 30% quota of direct recruitment that we had done. So now the next question remains is that whether quota will be enhanced or not. That the state will take a call, my lord. State has already accepted in the affidavit.
State is already accepted, my lord. It's not implemented.
No, now, you see, this is with regard to which promotion? Promotion for which year?
My lord, promotion from assistant.
No, for
excise-
which year? Which year?
My lord, it's not here, my lord. It's the entire thing is that is based on the stagnation in respect of the assistant inspector of excise, my lord.
Hmm.
It has to be done. Suppose it is done today, it will be followed from tomorrow.
My lord, may I indicate one thing? My lord? In 2009, my lord, a selection process was initiated for filling up the post of inspector of excise. That was challenged by them, my lord, on the ground that it exceeds their, my lord, claim quota. So my lords directed us to confine our selection to the proposed quota of 30% direct recruitment. That we have done, my lord. We have not violated that part, my lord. So now the issue remains, my lord, whether this quota for this assistant engineer will be enhanced or not. That has been admitted by the state, my lord, that they are
Assistant inspector.
assistant inspector.
Huh.
For promotion to the post of inspector of excise, my lord, what will be the promotional quota and what will be the, my lord, quota fixed for the direct recruitment?
So the cabinet memorandum said it
Everything
is
were prepared, my lord.
60%.
Yes, ma'am. Everything were prepared, ma'am, but the final decision was not taken. Apparently, ma'am, because of pendency of result petition. If,
Now?
my lord, there is one paragraph of an affidavit that from that, my lord, this petition may be allowed, my lord. But this was an affidavit filed by the respondent number 1, my lord, on 19/7/2012. Srimati Jabin Rahman.
Yes. Para?
Paragraph, my lord, would be 11. Page 3. That with regard to the statements made in para 13 and 14 of the petition, it is admitted that there is
Para 11.
11, my lord.
Para 11 doesn't begin with that.
Well, there are two affidavits, my lord.
We are referring to the affidavit filed on 29th of April.
No, 29/7/2012, my lord. There are two affidavits by the same person. my lord.
Two affidavits. No, there is only one affidavit here.
One is July 12, my lord.
Oh, yes, July 12, no?
Yes, 19 July, yes.
Yes, my lord. That paragraph 11 of that, page 3.
Paragraph 11. Yes.
That with regard to the statements made in para 13 and 14 of the writ petition, it is admitted that there is stagnation in respect of promotion from the cadre of assistant inspector of excise to the cadre of inspector of excise at present. At present, the quota for promotion to the cadre of inspector of excise is 40% from the cadre of assistant inspector of excise and 10% from the cadre of UDA of the office of commissioner of excise, joint commissioner of excise and chemical examiner. It may be mentioned that government has decided to fill up only 30% post of inspector of excise through direct recruitment till final outcome of the case, cabinet decision is received. So, my lord, now the cabinet has to take a call whether it will be enhanced or not.
We cannot direct the cabinet.
Yes, so, my lord, may allow us to do the needful, my lord. Even if they remain.
Was there any interim order?
There is an interim order, my lord, to not to fill up beyond 30%. That we comply with, my lord. But because there is a rule in force which goes against the interest of the petitioner, some of them could not be promoted also, my lord. They are not neither getting from this side.
What does the rule say?
Rule says, my lord, it is.
Is it enclosed here?
Rule is 40 and 60, 40 and 50.
Is it enclosed here?
My lord, it's not enclosed here, but it's mentioned, my lord, in
40 and 60.
no, 40 and 50
The percentage.
percentage.
So what happens to 10%?
10% is from UDA, ultimately 100.
What is UBA?
UDA.
UDA.
UDA working in the office of commissioner.
Okay,
commissioner,
10%.
10%.
And the others are assistant inspector
40.
to inspector.
40.
40.
And 50 for direct recruitment. That's the rule.
Now they want 60.
60.
Or the cabinet memorandum said it was 60.
60. At that stage, the writ petition was filed.
So 60, then 30 and 10.
10. Yes. But I'll just take only.
In principle,
one,
it was
1 minute,
accepted also.
I'll take only 1 minute. At one point of time, it was 65 from assistant inspector to the inspector. At that point of time, as they did not implement, then they approached this honorable court. And then this honorable court said, no, you are taking the decision, you can't sit idle. You have to do something. So the secretary was given the direction.
No. Was the cabinet decision taken?
No, my lord. Memorandum was prepared.
Memorandum was
prepared. The writ petition was filed.
Cabinet decision was not taken.
Cabinet decision was not taken when the authority.
Huh?
So let us take that call, my lord. Let the state take a call, my lord. Because it was almost on the verge of allowing that quota to them, my lord. They filed this writ petition.
No, there is no difficulty in government taking a call.
There is no bar, my lord, but government
There is no bar. The government has not taken a call.
Exactly, my lord.
Now,
so, my lord,
in order to close this writ petition,
since, my lord, it is in the realm of framing a rule, my lord, instead of passing a specific mandamus, my lord.
No, we are aware of that.
My lord.
The grievance in the writ petition, the prayers in the writ petition is to mandamus directing them to promote.
My lord.
By implementing the decision reflected in the cabinet memorandum.
That
but cabinet memorandum
yes,
decision was never taken.
Exactly, ma'am.
So your first prayer goes.
Exactly, ma'am. So let the cabinet take the decision and proceed, my lord. That is the only.
In the meanwhile, what is to be done?
Let the writ petition be closed, allowing the state to proceed with the cabinet memorandum that they propose to. Depending upon the outcome, my lord, they may be agreed, they may not be agreed, my lord.
No. Cabinet memorandum is not going to happen today, tomorrow, day after. Cabinet order. The order decision of the cabinet. Now, in the meantime, if there are promotions to be made, the rule has to be followed.
The promotions will be, my lord, as
per the rules.
No, as they desired that it will be 30% for the promotion. Because those posts are till date kept for us, my lord.
Mr. Counsel, your prayer in the writ petition is issue a mandamus.
Yes.
In terms of the cabinet memorandum. But cabinet memorandum is a proposal.
Yes.
There's somebody, the cabinet will have to take a decision. That decision, the additional AG says has not been taken. So until that decision is taken, the rules will prevail.
My lord, actually cabinet memorandum, that decision is taken if your lordship looks at page 26.
26.
The draft, next page is the draft amendment that has not been implemented. decision is there for 60%. Now the amendment of the rule has to be
That-
made in respect of
Page
5.
26, it says down below, last paragraph, 26. Now cabinet approval is sought for time. These are the memorandums to be placed before the cabinet, man. Last paragraph of page 26. It is not a cabinet approval, it was for the approval.
Hey, no.
It starts from page 24, my lord, and Annexure 7. Cabinet memorandum, the file number is there, circulated under Rule 17 of the Assam Rules of Executive Business. This, though they have agreed for the 60%, they cannot give it to us unless and until the rule is amended.
Cabinet rule approval.
Have you checked up Rule 17 of the Executive Business Rules?
No, ma'am.
Please do. Rule 17. darling. This is prior. This proposal has to be circulated.
Yes, ma'am.
So this is not a decision. This is a proposal.
There is one more particular fact, preceding to this cabinet, page 21 of the repetition. There was a repetition filed by the same association.
Earlier.
The state on principle agreed, earlier repetition of 2007, page 21.
Yes.
Second paragraph says the issue. The petition is an association of Assistant Inspector of Excise Department of so-and-so in terms of Rule 5C. So-and-so the quota for, this was the quota, they prayed for enhancement, the operative part, last paragraph. Having regard to the recorded facts and the issues raised, I am of the view that mode of disposal as suggested commons and for acceptance, the authorities have decided to enhance the promotional aspects of a particular category of officers. Understandably, on convincing ground, they cannot afford to drag a cold feet in the matter indefinitely. This petition thus stands closed with a direction to the Secretary of Assam Excise Department to take an appropriate decision on the petitioner's representation. Needless to say that as the members of the petition await for their promotion to the higher post and their future service careers significantly depends thereon, the exercise so ordered public so and so. So, in the process of challenging 2009 advertisement, the petitioners are also losing their claim of higher quota, my lord. Otherwise, in the meantime, state would have come up with that amendment of rules, my lord. So, my lord, direct the cabinet to take a decision, my lord, within, or remand it to the cabinet to take a decision within 3 or 4 months.
We got directly cabinet to take it. Why should we direct?
Remand it, my lord.
No, it is for the department to pursue the matter.
Yes.
Not for us to tell the cabinet what they should do.
No, I'm not saying what cabinet should do, my lord will direct.
It is for the department. The department will, if the department seeks to amend the rules, they'll have to take necessary steps for getting an approval if required.
It should be remanded to the department.
Which is what was your representation earlier?
My lord, for this only, my lord.
Then this has already been granted in terms of the earlier order.
Yes, my lord.
Page number 22.
In fact, while we are doing that, my lord, the requisition was filed.
My lord, the earlier order was when the department thought of 65% and that was not doing it. After this honorable court passed the order, they have circulated and took the view of all the departments, and then they came to the
You probably thought that this cabinet memorandum was a decision of the cabinet.
My lord, if your lordship,
It appears to be.
I understand. If your lordship looks at to page 22, 22 once, my lord.
Yes.
My lord, is the paragraph starts with following a series on top, my lord.
Yes.
Then there is a date, my lord, in the meeting held on 4/5/2007 to 65%. My lord got it. From then only this writ petition was filed. After that, different views of all the other departments were taken, and they have come to the conclusion that they can give it to 60%. And as they were not doing it, that is the reason we approached this honorable court. Okay, from 65, you have brought it to 60, but at least implement it.
Okay, heard learned counsels for the parties. This petition was filed by the petitioner association, who have appeared before this, who have approached this court in representative capacity, representing the grievances of the members of their association. Stop. The members of the association are the officers and staff, including the assistant inspectors of excise and working under the Department of Excise, Government of Assam. It is submitted that the association is a recognized association under the Government of Assam. The assistant inspectors of excise promotional avenue to the next higher post is the inspector of excise, and as per Rule 5.3 of the Assam Excise Service Rules 1990, the promotional quota is earmarked at 45% of the vacancies available.
My lord, is 40%.
Huh?
40%.
You said 45 here.
Yes, some mistake is there, my lord.
40%. Stop. Then 50% is reserved for
Direct recruit.
direct recruits to be appointed to the post of inspector of excise, and 10% was reserved for promotion from the cadre of UDA. Stop. In view of the limited promotional avenues, the members of the association are represented before the government, the competent authority, and after a series of discussions, it was held that the promotional quota was to be increased to 60% as against the demand of the members of the association for increasing it to 65%. Stop. In view of the discussions held between the members of the association and the competent authorities, a cabinet memorandum was circulated for being placed before the cabinet. Stop. What is the date of the cabinet memorandum? Cabinet memorandum was circulated by the
Well, the date is not.
file number EX 151/2004. Stop. In the said cabinet memorandum, it was mentioned that the increase for promotional quota up to 60% in respect of assistant inspector of excise to the cadre of inspector of excise was placed for cabinet approval. Stop. Stop. It is tried to mention here that earlier, since the grievances of the petitioners were not addressed, they had approached this court by filing WPC number. Where is that order?
Well, that order is
Page 21, man.
page 21. My lord.
By WPC number 4916 of 2007, which was disposed of on 19/1/2007 by a coordinate bench, directing the respondents, namely the excise department, to look into the grievances of the petitioner association and take appropriate decision on the representation filed by the petitioner. Stop. And the said direction was required to be implemented within a period of 3 weeks from the date of receipt of a certified copy of this order. Stop. it is submitted at the bar that pursuant to this direction, the discussions were held between the petitioner, members of the petitioners association and the competent authority, leading to the cabinet memorandum, which was circulated for a proposal for enhancement of the promotional quota uh, in respect of promotions from an assistant inspector of excise to inspector of excise to 60% as against the existing 40% under the rules. Stop. An affidavit filed by the respondent excise department Mm, affidavit which was filed by the excise department on 19 July 2012. So you can say in the affidavit filed by the respondent department on 19 July, there is an averment that the proposal was placed before the cabinet. However, the cabinet decision in the matter was awaited. Cabinet decision in the matter or the outcome of the present proceedings are awaited. Stop. Today when the matter is called up, Mr. P. Goswami, learned additional AG, appearing for the respondents, submit that the department is in agreement with the proposals made by the petitioner association for enhancement of the promotional quota, for enhancement of promotional quota from 40 to 60%. And the same was duly circulated by the cabinet memorandum dated so and so. However, in view of the pendency of the present writ petition, no cabinet decision was taken. Stop. He submits that if the writ petition is disposed of at this stage and liberty is granted to the respondents to pursue the matter, then further steps as required for placing the matter before the cabinet will be taken up. Stop. Such submission made by the additional AG before the court is not objected to by the counsel for the petitioner. In that view of the matter, taking in on record the submissions of the additional AG, that the department will take necessary steps for placing the matter before the cabinet in terms of the discussions and parleys held between the petitioner association and the respondents for enhancement of the promotional quota of assistant inspectors of excise from 40% from the existing 40% to 60% as proposed. This writ petition stands closed. in terms of the submissions made by the respondent counsels and accepted by the counsels for the petitioner, stop. The petitioners, the respondents are expected to proceed in the matter in right earnest and take all necessary steps for amendment of the rules, for all necessary steps for placing the matter before the cabinet for its approval, and thereafter proceed in terms of any such decision as may be taken by the cabinet. In terms of the above, writ petition stands disposed of. Interim orders, if any, stands vacated.
My lord, I think one date that High Court's earlier order date is 19/9/2007. My lord possibly said 19/1.
All right, 19/7. Side to put it.
19/7. Deeply
Okay.
obliged, my lord.
FCI.
Lord.
It's covered by that matter. the earlier judgment which I had rendered? Pecuniary loss.
Here, your lordship, what has happened? There was an excess in the earlier case. And in our case, my case was
Shortfall.
short. That's the difference, your lordship. But one or two paragraphs of your lordship finding, your lordship, probably
Where is that order? Where is the inquiry order?
inquiry report or your
Report.
report, your lordship. I have annexed it in my additional affidavit, your lordship.
Additional affidavit.
Page 78. Document.
This is a separate inquiry. It is not the earlier inquiry.
No.
Separate.
Separate.
But the petitioner is also a shed in charge.
Trading. And in fact, your lordship, my case is your lordship rather than on
Depot in charge. No, I think it was shed in charge. Perhaps. Subject to correct. Yes.
food storage depot at the state in charge, your lordship. State in charge of food storage depot.
There are findings against you.
Lordship, finding is there, your lordship, but only thing, your lordship, there are two aspects.
Hmm.
First of all, your lordship, the proportionality of the punishment, your lordship, that is the main contention on my part, your lordship. First of all, your lordship, if your lordship, the charges that has been brought, your lordship, under 32, your lordship,
Hmm.
and the 32(1), your lordship, will get it, your lordship, in the memorandum of charge, your lordship, that is at page 20, your lordship.
20.
20, your lordship.
Huh?
Yes, your lordship.
20 is your prayer.
Page
23.
page 20, your memorandum of charge. Lordship may take up the,
27, I think, is your statement of
your lordship
computation.
may take up your lordship amended writ petition. There is an amended writ.
Amended repetition. Okay. Page 20. What did you amend?
Your lordship, the appellate order, your lordship, which your lordship has, we have not put to silence since it was not served on me, your lordship.
All right. All right. Now let us come to the charges
Lordship.
at page number 24.
Lordship. 24 is the, your lordship, statement of your lordship
Allegations. Yes.
allegation.
Charge
Regional
number
office
1
will,
is
after peripheral counting of stocks at step number 2, on the declaration of stocks as on so and so submitted by the said insert, detected 3944 packets of rice grade sort against 20 stacks. The counting sheet was duly signed by Sri so and so, the said insert step number 2. A district office committed from FCI district office to supervise 100% delivery operation of weighment of rice grade stock during the month of September 2010, detected shortage of 4077 bags of quintal in respect of rice grade 162. The total loss comes around to 44 lakhs. On verification of record, it reveals that Mr. Jayanta Mohan Singh has taken proper care. He could have saved the property of the corporation, and the corporation would not have sustained such huge loss to the tune of so and so, so and so. By the above act, the Jayanta Mohan Sharma Singh so and so Ramnagar failed to maintain absolute integrity, devotion of duty, made himself liable for departmental proceedings for contravention of so and so, so and so. Now, your lordship will kindly note page 25, your lordship, second paragraph, your lordship.
Hmm.
That is that he could have taken proper care, your lordship. There is as such, your lordship, no allegation of theft, misappropriation, etc. It only says, your lordship, proper care, your lordship. That's the one point, your lordship will kindly
No,
note.
but you are the in charge.
Yes, your lordship.
Because of your lack of proper
Care.
supervision.
Lord.
There is a pilferage of or loss of bags resulting to such and such amount.
Lord.
So it need not be that you have stolen it,
Lord, that's what
but you are responsible for maintaining it.
Your lordship, I may be responsible, your lordship. That's I am not denying, absolutely denying my responsibility, your lordship. But the fact remains, your lordship, that the allegation of, my point is this, your lordship, allegation of theft, misappropriation, etc. is not there in the charge, your lordship. That's one point, your lordship. Now, your lordship will, it's your lordship, if your lordship, the language we go through, your lordship, at page 25, your lordship, it's a case of, your lordship, negligence on my part, your lordship, even assuming, your lordship, that this is allegation is, your lordship, proved or correct, your lordship.
Yes.
Now, your lordship, my case is of initially, your lordship, of total denial, your lordship. I have not explained anything, your lordship, in my reply. I only said that I deny the charges, your lordship. Now, your lordship may kindly come to inquiry report again, your lordship.
Page number?
Page 76, running page, your lordship.
76.
Additional affidavit, where, your lordship, I have annexed my inquiry report.
Yes.
Now your lordship will kindly come to page 84, your lordship, internal page 9, your lordship.
Yes.
Your lordship will find, your lordship, the presenting officer's brief, your lordship. Now your lordship received the brief from the presenting officer, so and so. In his brief, considering the documentary evidence exhibited during inquiry and witnesses examined both in prosecution and defense, he mentioned the charge official Sri Jayanta Mohan Singh, AG2D, is not free from the collective responsibilities of Article of charges frame against him, your lordship. Now, this word is very important, your lordship, in the light of your lordship, the present case, your lordship. Now, by saying so, your lordship, the presenting officer who is holding the brief on behalf of the management, your lordship, they have, your lordship, categorically stated that it is a collective responsibility of the entire staff, your lordship. I cannot absolve myself from that collective responsibility. Now, the question is, your lordship, whether the authorities has proceeded against the other officers or not, your lordship, who are working under me, your lordship. Now, your lordship, therefore, your lordship, that was an important aspect of the matter, your lordship, which disciplinary authority, your lordship, as well as the inquiry officer, your lordship.
No, the first question is whether these charges are at all proved against you,
No,
as far as you are concerned.
I am, your lordship, assuming, your lordship, for a moment. Your
We
lordship.
find in the inquiry report that you have accepted at some place. Some
Lordship, that there is a, your lordship, shortfall, your lordship.
shortfall you have accepted.
Question of deny. My explanation to that was, your lordship, in the inquiry procedure was that, your lordship, it was a cumulative loss, your lordship, over the years.
No, very true, but non-proceeding against other members who could be involved,
Lord.
is it a good ground not to proceed against you at all?
Not to proceed against me, your lordship, but your lordship, until and unless, your lordship, liability is fixed in respect of others also, your lordship. Only then, your lordship, one can find a conclusive proof that this person is, your lordship, guilty of the negligence. Your lordship.
No, but in view of your statements that you have accepted
Lordship,
the loss.
Loss is there, your lordship.
So in a shed where you are the in charge, where you required to maintain registers for goods coming in, going out, damaged, unless you are able to explain that this loss is not attributable to you on the basis of the peripheral counting and the verification of the documents or the registers which are maintained by you, how do you disprove the allegations that you are not responsible?
My point is this, your lordship. This aspect, your lordship, which I am pointing out, your lordship, this aspect is
No. We want to understand two things. Number one, is it your case that the inquiry itself could not have been initiated against
No,
you?
that is not my case.
All right. Number two, that the charges against you are not proved, lack of evidence, etc. Third is, may be proved, but the punishment
is disproportionate. That is my case, your lordship.
So you're only with the
Only
punishment.
this punishment, your lordship.
All
And
right.
your lordship will kindly note that I am pointing this out in the context of your lordship, of my argument that why this is disproportionate, your lordship. If it is a collective responsibility of the entire, your lordship, officials, your lordship, your lordship.
That is why in any organization there is a hierarchy.
Lordship, that's what your lordship.
Otherwise, all employees are equal.
Lordship, that's what your lordship. Now, if your lordship, you are allowing others to go scot-free without investigation, without inquiry.
That could be a different issue, but
No, that is in the context of your lordship punishment. I may be, your lordship, they may go against me, your lordship. They may not go against others, your lordship. But in the context of giving punishment, your lordship, in my humble submission, your lordship, that will assume significance the issue of your lordship collective responsibility, your lordship.
No, but departmental inquiry principles don't necessarily prevent imposition of punishment only on one person.
No, your lordship, but your lordship, punishment they can impose, your lordship. Now, what will be the punishment, your lordship? Now, your lordship will kindly see, your lordship, that
FCI rule এখন আছে। Firstly, you'll have to see what is the misconduct.
Lordship. That is your lordship will get it, your lordship. 32A of the FCI guideline, your lordship.
Guideline,
It's not guideline, your lordship, regulation 1971.
page number 32.
Lordship. In my 24. Okay. Regulation, your lordship, clause 30, para 32A.
What is that regulation number?
Your lordship, 32, your lordship,
32 capital A.
capital A.
Yes.
Without prejudice to the generality of the term misconduct, the following acts of omission and commission shall be treated as misconduct. Now they have charged me under this also, your lordship, without the theft, fraud, dishonesty in connection with business of, or property of the corporation or of the property of another person within the premises of the corporation. Now then, your lordship, 5, acting in a manner prejudicial to the interest of this corporation. And 9, neglect of work or negligence in the performance of duty, including maligning or slowing down the work. These are the essential.
Where are the punishments prescribed?
Punishments, your lordship will get it at para regulation 54, your lordship. Section 5. There are, your lordship, 1 to 4, your lordship, Roman 1 to 4, your lordship, minor penalties, and major penalties, your lordship, reduction in lower stage of time scale of pay for a specified period, reduction to a lower time scale of pay or post which shall ordinarily be barred to promotion of the employee to the time scale of pay or post from which he is reduced. Compulsory.
What was the punishment imposed?
Your lordship, removal from service. Your lordship. I have already retired, your lordship. Age of superannuation has already been over. Now, your lordship, in this context, your lordship, if your lordship go to the disciplinary authority's order, now, why, your lordship, removal, not compulsory retirement, your lordship, or any other punishment, your lordship, major punishment, your lordship, except removal or dismissal? There must be certain reasons for that, your lordship, and the order must disclose it, your lordship. Why? That's why, your lordship, I have, your lordship, submitted at the very outset that your lordship passed the earlier order, your lordship. There is a definite finding in that particular order. Observations made by this honorable court. Your lordship has made that in para 11, in the inquiry proceeding, no reference has been found in respect of petitioner's conduct or record of past performance referred to by the officer. There is no finding by the inquiry officer or the disciplinary authority that petitioner is a habitual offender and he has been found to have indulged in malpractices or misconduct in the course of his service in the past. Now, these are the factors to be taken into account by the disciplinary authority, your lordship, while giving a punishment, your lordship. Now, this will have to be reflected in the disciplinary authority's order, that this is the reason why we have gone for, your lordship, the extreme punishment of removal of service, your lordship. Now, without having proof, without having any proof, any finding that I have misappropriated, your lordship, or I have indulged in theft, your lordship, of the materials, your lordship, can they, in a mechanical manner, your lordship, punish me for for removal, your lordship, by which, your lordship, my entire pensionary benefits and other things I am being deprived of, your lordship. That's the point, your lordship, probably, your lordship, and the point which I have been shown to your lordship, that this is a collective responsibility, your lordship. In the context of that, Your Lordship.
Now, in so far as the punishments are concerned,
Lordship.
it does not reflect to the misconduct, is it?
Lordship.
Minor penalties, when minor penalties to be imposed, in
Lordship.
what categories of misconduct? Anything there, Mr. Roy Chaudhary? In the punishments, penalties, regulation 54,
Section 5.
in the penalties, there are minor and major. Now, which category of misconducts call for minor and which? Where is that? No. Misconduct is mentioned and penalties are mentioned.
For which
Ah,
that is not.
that is not there. Okay.
Now, Your Lordship will, if Your Lordship,
Yes, compulsory removal means no pension.
compulsory removal pension will be there.
Huh?
But that they will decide, Your Lordship, how much pension I will get. In
No, in the
compulsory
punishment which is imposed on you, what?
removal.
Removal.
No, removal of pension.
Ah.
No.
So he's already got it. That's a part of his contribution.
But in compulsory retirement, Your Lordship, I will get some probably more benefits. Your Lordship.
No, not probably. You want to find out because you see, is there any authority you are relying on that in cases of collective responsibility, unless the guilt is pinpointed?
Lordship.
No
I have
punishment can be.
relied on 2 or 3 judgments, Your Lordship, which says, Your Lordship, that the factors to be considered by the disciplinary authority while imposing a punishment, Your Lordship. That's one, Your Lordship. And one judgment, Your Lordship, that's from our High Court, Your Lordship. The facts are slightly different, but one Your Lordship, plea I have taken, Your Lordship, that, Your Lordship, that loss is there, Your Lordship. But how the loss has been caused, Your Lordship, that has not been, Your Lordship, there is no finding to that regard by the Your Lordship inquiry officer. And to that extent, Your Lordship, one judgment, Your Lordship, that is Padmakanta Bora, Your Lordship, this is reported in 2012 SCC Online, Guwahati to 928.
Give us a citation again.
2000, I have a copy, Your Lordship. This person was also a state in charge, Your Lordship. Some facts are slightly different. Here also, Your Lordship, there is a loss, Your Lordship. While allowing the petition, Your Lordship, para 17, Your Lordship, may kindly.
Yes.
Para 17, Your Lordship. Throughout the inquiry report, the inquiry officer has emphasized only on the loss of stock, without, however, pointing out anything that such loss of stock was because of the misconduct of the part of the petitioner, Your Lordship. Now, how this loss has occurred, Your Lordship, that to that extent there is no finding, Your Lordship. In my case also, Your Lordship. And Your Lordship will kindly come to para 10, Your Lordship, on the point of collective responsibility, Your Lordship. para 10 and 11, your lordship.
Yes.
10, 11, and 12. That the petitioner has annexed the statement of witnesses as noted above. Out of 11 witnesses, 8 witnesses were examined by the inquiry officer on the petitioner. However, it is a fact that there was a loss of stock. In this connection, Mr. Gogoi, learned counsel for the petitioner, submitted merely because the petitioner was in the charge of go down, such loss could not have been attributed to the petitioner alone, as has been held by the division bench this court in so-and-so versus so-and-so, 2006 2 GLT 235. When there is a collective responsibility, only one person cannot be held responsible for alleged misconduct. At this stage, Mr. P.K. Royal Understanding Council FKI submits that the altogether 9 persons were involved in the case and accordingly they were charged with it. He fairly submits that barring the petitioner.
There is a division bench judgment
Lordship,
referred to. Where is that?
that your lordship, in fact, your lordship, 2006 2 GLT
2006
2 GLT, your lordship.
2 GLT. कौन निकाली? निकालिए, निकालिए. Take it down. 2006 2 GLT 235. Please take a printout. Two thousand six. Is it 2 or 1? Girish Chandra Sharma. Then 2006 1 GLT. You don't have a copy?
You could not find out your lordship. That's the problem. Today morning I tried to get copy. There, this pagination might have some citation. One
Yes.
So your lordship, on this that point of your lordship that there is no finding
Hmm.
of misappropriation.
Yes. Please carry on. Carry on. Yes.
This is your lordship relating to penalty of recovery due to the loss your lordship caused by an FCI employee your lordship while he was a depot in charge your lordship. There is a discrepancy your lordship. If para 2 your lordship will find the article of charges your lordship. Now this assumes importance your lordship in for two reasons your lordship. Please ask something. Now, during conducting investigation by a committee for the period 1991 to so and so, detected a discrepancy of 2971 bags of quintals sugar, fine, raw rice during the material period 3 so and so, being the stock holding official failed to discharge his duties sincerely and safeguard the interest of the corporation.
Yes.
Now, this was a loss your lordship will kindly see. Then your lordship, this honorable court, there is a punishment of recovery your lordship. Then your lordship may kindly come to para 10.
Hmm.
It is also considerable significance that no charge of misappropriation was leveled against the delinquent, not any finding of misappropriation was given by the inquiry officer. Nevertheless, the disciplinary authority ordered the penalty of recovery by assuming that it was delinquent who had misappropriated rice stock from the FCI go down. Now, your lordship will kindly see the question of proportionality also comes here, your lordship, because your lordship, in identical charges, your lordship, different disciplinary persons acting as a disciplinary authority, while your lordship giving a punishment of your lordship recovery, your lordship, and in present case, your lordship will find that this is a punishment of your lordship removal. Now, why two difference, your lordship? It shows, your lordship, the discretion that has been exercised by the disciplinary authorities, your lordship. There is no objective basis, your lordship. That's why, your lordship, I am submitting before this honorable court, your lordship, that this is an important aspect of the matter, your lordship, that disciplinary authority, while giving a punishment, why he has given given me the punishment of removal, your lordship, not any other measure punishment, your lordship. That is not reflected, your lordship. And that could have been reflected, your lordship, from the consideration of factors like, your lordship, my past conduct, your lordship, if your lordship, there is a definite finding of theft or misappropriation by me, your lordship, and if they would have gone for the, your lordship,
That's right. But there are other judgments referred to here. You're not relying on them.
Lord.
In both the judgments, there are references made to other judgments,
Lordship.
drawing out analogy to support the conclusions.
Here, your lordship, in this
Para 15, there is judgment referred to.
this is, your lordship. This I have gone when to your lordship, but this was related to your lordship. There is some discrepancies in the disciplinary proceeding itself, your lordship. That's why I have not brought.
Okay.
Now, so far as your lordship, this proportionality is concerned, your lordship,
Yes.
one judgment, your lordship, I am relying on, your lordship. That is 2007 4 SPC 669, your lordship. Para 17 onwards, your lordship, where the doctrine of proportionality has been discussed at length, your lordship. Para 17 to 19, your lordship. And more particularly, your lordship, para 19, your lordship. May I read para 18, Your Lordship?
18 and 19.
Lordship.
Okay.
Proportionality is a principle where the court is concerned with the process, method, or manner in which decision maker has ordered the priorities, reached a conclusion, or arrived at a decision. The very essence of decision making consists in the attribution of relative importance to the factors and consideration in the case. The doctrine of proportionality thus steps in focus true nature of exercise, the elaboration of rule of permissible priorities. This myth states that proportionality involves balancing test and necessity test, whereas the former permits scrutiny of the excessive onerous penalties or infringement of rights or interests, and a manifest imbalance or relevant consideration later necessity test requires infringement of human rights to the least restrictive alternative. Now, Your Lordship, these factors, Your Lordship, have not taken into consideration by the disciplinary authority while passing in the impugned judgment. It has referred to certain, Your Lordship, the inquiry report, Your Lordship, my comments on the inquiry report, Your Lordship, but Your Lordship, the factors that is required to be taken into consideration, that has not been taken into consideration, Your Lordship. And Your Lordship has, Your Lordship, in earlier judgment, Your Lordship, in para 11, Your Lordship, have given the hint as regards the factors, Your Lordship, which the disciplinary authority ought to have considered while imposing a punishment, Your Lordship. In para 11 of Your Lordship's judgment. Your Lordship.
What is that citation of the judgment?
Your Lordship's judgment, Your Lordship. That is, Your Lordship, probably I have downloaded copy, Your Lordship.
No, give us the number.
Oh, Lordship, that is WPC 4682 of 2012.
Disposed of on?
It was disposed of on, Your Lordship, 24/11/2023. That is the date of judgment, Your Lordship.
What is the name of the party?
Party is, Your Lordship, Mohammad Safiur Raja Chaudhary.
Safiul.
Safiur, S-A-I. Saifur, I have extra copy, Your Lordship.
That's okay.
SAIFUR, Saifur Raja Chaudhary.
Good. You're referring to para 11.
Para 11.
All right.
And in fact, Your Lordship, para 12 also, Your Lordship. And para 13, Your Lordship, may I read, Your Lordship? In the present case, from the materials available before this court does not reveal as to how allegation of misconduct can be substantiated against the petitioner. However, the fact remains that petitioner had himself admitted that non-recording of particulars in the respective ledger trade due to oversight. Whether such admission will amount to misconduct which will entail punishment of removal from service ought to have been appropriately decided by the disciplinary authority. That is the, Your Lordship, point, Your Lordship, I am trying to impress upon, Your Lordship. That has not been, Your Lordship, discussed by the disciplinary authority.
Hmm. Yes.
This is essentially, Your Lordship, my submission, Your Lordship. So in view of that, Your Lordship, probably the matter needs to be, Your Lordship, remanded back to the disciplinary authority to take a fresh call, Your Lordship, since it suffers from disciplinary authority's order, suffers from, Your Lordship, non-application of mind, and also, Your Lordship, that it is highly disproportionate in nature, Your Lordship, the punishment imposed on me, Your Lordship.
Yes. Yes, Mr. Roy Chaudhary. You may like to go through the judgments also. He has relied upon some judgments. Have you been given a set of list of the judgments? His only point is disproportionate punishment.
Lordship, before learned senior friend starts, your Lordship, one annexure, your Lordship, I did not point out, your Lordship. That was part of the record also, your Lordship, of the disciplinary proceeding, your Lordship. That is my annexure page 58, your Lordship. There was a circular, your Lordship, issued by the, that we have brought on record, your Lordship, in my proceeding, your Lordship. Page 58. Your attention is invited to the headquarters instruction issued by circular referred above, wherein it was entirely emphasized that the existing procedure for fixing accountability for storage and transit losses, your Lordship will kindly note that. My case is storage loss, your Lordship. Mentioned in headquarters circular dated so and so would be continued to be followed. Of late, the staff bodies have been expressing resentment over the manner in which responsibility fixed on the employees by issuing search sheet and making recoveries from them for abnormal, unjustified storage and transit losses arbitrarily and without following the procedural formalities as required under so and so regulation 1971. The union has also been emphasizing that no employee be made responsible for such food grain losses unless his her involvement in theft and misappropriation is proved beyond doubt on the plea that the quality of quantity losses of food grains during storage are obvious and unavoidable due to natural factors beyond the control of employee. Also, there is no point to make employees responsible for transit losses and to ask them to visit their destinations to verify the shortages while they are already got the consignment verified from the representative of the insurance company and so and so. The whole matter was discussed by the FCI management with bank, BAK, NK Sangh and so and so union in a joint meeting of so and so, wherein after detailed deliberation, it has been decided that henceforth it would be ensured by all concerned authorities that no recovery in respect of storage and transit losses should be effected without the theft and pilferage and malafide being proved, your Lordship. All the competent authority has advised that they should pass speaking orders now malafide, etc. on the part of each employee while imposing penalties, making recoveries from the field staff consequent upon investigation of so and so. This instruction may be strictly followed. Now, your Lordship, here, your Lordship, no malafide has been, your Lordship, alleged or proved in my case, your Lordship. That's why we have brought this to record, your Lordship, which has not been considered either by the inquiry officer or by the disciplinary authority, your Lordship. This aspect, your Lordship, I also point you. Okay.
Yes. Yes.
Start
42. Yes. You want 42? Yes. Yes.
as on 27th and as on 27th and date on 9th
back to price they were set by ROP as of 2010.
Mr. Roy Chaudhary. Sorry, Mr. Roy. His grievance is not with regard to the inquiry or the findings as such per se. His grievance is with regard to the punishment imposed.
I understand.
And the punishment imposed according to him,
I am taking it way to the object. Way to the object.
and read with a circular issued by FCI, which is a
Circular is not part of the, that is a different, that circular is transit. Here it is not transit. This fee is different. That's why I'm reading it. I'll read, complete the reading, Lordship kindly. All right, para 4 then para from the record is observed that Lordship kindly have got from the record observed that government had issued out all the stock received in July 3rd tax by showing nominal storage loss, even those tax where shortages were detected by RO. From the act of the James King, submitted that he had been trying to nullify the findings of the ROPV by manipulating the stock, but he did not find out the shortage detected in ROP. During 100% weighment of price data conducted by ROP, SATO, on terms of the declaration of price stocks were given by James Singer that is as per declaration, as on 1697, there were only 3 stacks, stack numbers so and so. As per record, all these 3 stacks were seized during August 2010. Out of these 3 stacks, 2 stacks were not found existent. Rice stacks are stacks of captive stacks. The stacks were missing. So any man of prudent thought will find it responsibility is satisfied. Physical against stack number 22, against the declaration of 1671 pack. The weight of 91 pack found for 30. And during 100% payment, audit calculation 4077. Another 12. Now, next last para. The joint government AG2 in his reply dated 12 towards the short memo by the manager PBT, filed letter dated as though he has put forth the reason for occurrence of shortage of 3944 packs, but it cannot be accepted because there is no evidence of long storage, 2-3 months, and large scale damage of bottom layer pack, which was the peak of the stack as per the depot report. If the damage of bottom layer bags were factual, then it was also his duty to collect all these bags to drain, because these damaged grains are also a part of the food grain received by the bottom that misuse of any kind of corporation property without prior approval of the company. Considering all the above factors and considered, there is finding of one, the required officer conform the standard of proof to establish the guilt of the starting suspicion, the then said in church at number 2 FS Ramnagar, and undersigned thing with the findings the required officer. Now the undersigned is being pass the order. So his plea is bottom layer, it is not any other, and tax are missing.
So what is his reply to that?
He doesn't have any reply. He doesn't have a reply. So against WS, he then reply. He should have given a written reply to us. So the disciplinary authority passed the order writing. And Lordship kindly, I have one copy.
You give the citation.
Lord. And 10, 106.
With regarding quantum, my lord. I'll read it, my lord,
Paragraphs?
my lord, in, on the purport 7. But,
Yes.
we para 10, 7 and 8.
7 and 8
Yes.
in Manupatra.
No, yes,
No, Manupatra.
para, my lord, 6.
6 and 7.
My lord, I hand up, your lord.
Yeah, we have a copy. Oh no, sorry. This is Ramlal Bhaskar.
Date of inter versus Ramlal, para 7 and 8. That's the difference. The scope of the, my lord, I'll read para,
No, which judgment are you now reading?
Deputy Commissioner,
Deputy Commissioner.
Deputy Commissioner,
There you are reading para
6.
6.
It says, when the charge is has happened in the instant case, it's the disciplinary authority. With whom lies the decision to decide what kind of punishment is of course, the decision has to be examined objectively, keeping in mind the natural gravity of the charge. The disciplinary authority is to decide a particular penalty specified in the relevant rule. Host of factors go into the decision making while exercising such a decision, which include part from the nature of the gravity of conduct, past conduct, nature of the duty assigned, whether the authority assigned the previous penalty, if any, and the discipline required to be maintained in the department or establishment where it works, as well as activities the cost, if any, agree. The order of appellate authority, while having a relook in the whole case, obviously examine as to whether the punishment imposed on the authority is reasonable or not. If the appellate authority is the opinion, the case warrants lesser punishment, it can reduce the penalty imposed by the authority. Such power, which bears the appellate authority department, ordinarily not available to the court or the tribunal. The court or tribunal undertaking to review the matter is not supposed to substitute its own opinion, reappraisal of facts. In the exercise of power judicial to however, the court can interfere with the punishment imposed when it is found to be totally irrational or is outrageous law. The limited scope of judicial review is permissible and interference is available only when the punishment is shocking with disruption. That is the law laid down. Well, it is only after the disciplinary authority considered this. And your lordship kindly have a look at Ramlal. I have given a copy below statement of which Ramlal correspondent. What correspondent?
No, 1 minute.
Very
No, there is, see, the only point for argument is this in view of the host of list of punishments that are prescribed under your rules, starting from censure to removal.
removal.
These are all punishments at the to be imposed at the discretion of the disciplinary authority. Now, in the facts of a particular case, which punishment is to be imposed? Is it not required for the disciplinary authority?
It's left with the authority.
No, I know it is left, but should the discretion not be expressed in the order, disciplinary order? You have narrated everything. The disciplinary authority has narrated everything, except for the fact that for in view of these particular attending facts and circumstances, this punishment is appropriate.
Oh my lord, this, this is obvious, my lord. This should not be, these two words should not be stated, my lord.
No, need not be said. We are just giving you an example.
This
From
is-
the order, it doesn't appear that the disciplinary authority decided as to the appropriate punishment from the list. Because it starts from censor. Why not a censor? Why not a stoppage of promotion?
No, he has given
Why
some-
not a compulsory retirement?
He has narrated.
He is narrated.
I understand Lordship is indicating. The authority ought to have said that since I
Because this is what we are examining.
find this, the misconduct to be so grave.
No. We are not asking for adjectives or superlatives. We are saying that there has to be, from the order, we must be able to reflect the mind of the disciplinary authority that in view of these, this is the appropriate punishment to be granted. We may agree, we may disagree.
So that's like
Then anyway, yes, you are referring to which judgment?
ordinarily, my lord, it is up to the
Which judgment?
or Ramdal, my lord,
Ramdas. Ramlal.
State Bank of India, Ramdal,
Yes.
para 7 and 8.
Para 7 and 8.
Coming to the married,
No, this is just 1 minute. 1 minute. Let us. This is not reported in SCC.
it is reported from 11, no, 11, 10 is
2011.
10,
349. Two 49. Yes.
one percent, para
Please read the paragraph.
para 7. Coming now to the contention evidence, fine. The inquiry officer found the charges 1, 2, 4, and 6 have been against the respondent. Number 1. While arriving at the finding of the charges, proof is respondent number 1. The inquiry officer has considered the number of documents marked as exhibit and has also considered the documents on behalf of the respondent number 1. Marked as exhibit. Findings of the inquiry officer were based on evidence and the appointing authority had agreed to the findings of the inquiry officer. This court has held the state of disbursement and the High Court is not substituted in a proceeding under as court of appeal over the concerned to determine whether the inquiry has been by the authority in that year and according to the and whether the rules of natural justice are not high. Where there is some evidence which the authority has trusted and which the evidence may reasonably support the delinquent officer is guilty of the crime. It's not function of the high court. Arrive at a decision. That's the noble of one of there are other
Okay.
Short reply, Your Lordship.
Ah.
So far as Your Lordship, my honored senior friends reference to the disciplinary authorities order, Your Lordship, at page 41.
Ah.
That Your Lordship, that the out of these 3 stacks, 2 stacks were not found in existence. If Your Lordship, these finding is given by the disciplinary authority, it is the beyond Your Lordship 30 or also Your Lordship inquiry report, Your Lordship. this will be added ground for me to your lordship challenge this your lordship. Because your lordship neither the charge neither in the charge this has been put to me, your lordship, nor the inquiry report there is a finding in this regard, your lordship. Now that by doing so, your lordship, the disciplinary authority has virtually go beyond the inquiry report, your lordship, as has been shown by my learned senior friend, your lordship. Because without this being placed to me, your lordship, giving me an opportunity at the during the disciplinary proceeding to explain my conduct, your lordship, this could not have been, your lordship, even considered by the disciplinary authority. By doing so, your lordship, this itself, your lordship, VCF's disciplinary authority's order, your lordship. It shows, your lordship, predetermined approach taken by the adopted by the disciplinary authority. And so far as your lordship laws, these citations, your lordship, placed by my learned senior friend, your lordship, these are, your lordship, settled principle of law. In fact, your lordship, in 2013, the first judgment relied on by learned senior counsel, your lordship, it has been referred, your lordship, the factors to be taken into account by the disciplinary authority. And my entire case is that these factors are not considered. This is my humble point.
Where is that portion where these two stacks are missing?
That is, your lordship will get it at your lordship page 41.
No, what is 41?
Page 41, your lordship, that is the disciplinary authority's order, your lordship.
No, in the inquiry report.
Inquiry report, your lordship, that is not there, your lordship. That the two stacks are missing. The finding starts from, your lordship, page 10, 9, your lordship, defense reply. Then, your lordship, page 85, your lordship.
Yes.
Running page 85. Your lordship will get it, your lordship. There is no mention about, your lordship, that two stacks is not there at all, your lordship. It was not their case even in the charge sheet also.
Yes.
This much.
We would have taken in a big ticket.
But your lordship, it is when it is apparent, your lordship.
Disciplinary authority will have considered all the documents available on record and then. And so when Padma Kalpa Das relied on by that. Padma Kalpa, it's not a different question.
That I have pointed out.
Yeah. He was not given any work to do. That's why this authority says, even if he was not given any work to do.
I think there was a that was on the context that he prayed for some time when it was indefinitely asked for and then subsequently.
That is a different.
Okay. We'll put it up for orders on 1st of February. 1st of February.
Deeply obliged, your lord. He has retired from service. His date of retirement is 31st December 2015.
Oh, 1 minute. 1 minute. 1 minute. 1 minute. A2 report.
On second. February 6 তারিখে এটা ফিক্স করতে 8 তারিখে কোন 8 ফেব্রুয়ারি ও ঠিক আছে
Including FCI.
8 ফেব্রুয়ারি no February
Yes. Yes.
Please, your lordship, my lord, these matters, my lord, the
Which
addition-
matters from?
10 to
10 to 17, my
What
lord,
is there?
pertains to an area being included in the,
Ravasam.
yes, my lord, the additional advocate general be appearing in this matter, my lord, conducting this matter.
Hmm.
If it may please be taken in the second week of February, my lord, subject to the convenience of the sort.
What is your prayer here?
My lord, some areas which are not non-tribal areas, predominantly non-tribal areas, those were included in the Ravahasang area. If it is they are included, then there will be predicament for the non-tribal people. That is why these matters were filed.
Where is that order of the inclusion of these areas? Where is that order?
My lord,
Where is it
today-
reflected?
Today, matlab, I am also in difficulty. Some of the files are misplaced. If lordship takes up with that, my lord, February 13th, my lord, will come up with all preparation.
Hmm?
If lordship pleases to take up it up on.
No, we wanted to see the order.
The order, my
Only the order. As to what order you are agreed with.
My lord, if lordship takes up writ petition 3744.
You are agreed with the notification 22/2013.
Yes, please. That is at page 37.
Hmm.
In case of writ petition 3744 of 2013. That is Batakusi or Janajati Surakha Committee.
This is not a sixth schedule. Is it a sixth schedule? No.
No, initially, my lord, it was not a sixth schedule.
Hmm.
It is in normal areas of local inhabitants. But when the Ravahasang Autonomous Council was
No,
declared.
that's what I'm asking you. It is not a sixth schedule. Autonomous Council.
Ravahasang, yes, my lord. There's an act.
There's an act, my lord.
Under the sixth schedule. I'm not mistaken.
Your area falls under which area? Which village council?
Kun village council.
My lord, this Batakusi or Janajati, there are many villages, my lord. There are, if lordship comes to page 40 onwards, page 39 onwards, my lord. These are the villages, my lord.
Did you file any representations before the authorities ventilating your?
We participated in hearings conducted by the deputy commissioner.
No, pursuant to the notification.
Yes, pursuant to this
So
notification.
what orders were passed?
Nothing, my lord.
Huh?
Nothing. Nothing has been done on the hearings we participated. We raised objections. We have given statement in the report.
Ravahasang is not in the sixth schedule.
Not there.
Not there, my lord. It's not in the sixth schedule.
It is not in the sixth schedule.
Well, if not inconvenient, well, can it be on 13th of February?
13th, no, for it. 13th, no. Believe that, but it's the same.
See, these are all matters, so we are not normally inclined to grant
Well,
you
I appreciate
time
it.
to that extent.
My lord.
So you tell us a shorter date.
Huh, on
Why
6th.
can it not be in January itself?
Uh,
Can it be on 6th of February? It's a Tuesday. If not inconvenient to your lord.
8th of
8, I have some other matters. my lord. 6th, my lord.
all right, 6th,
Well,
6th of February.
Yes.
Right.
At the request, a joint request. Items
10 to
10 to
17.
Fine.
Yes.
Right.
What is that issue pending? And what are your prayers here? What is the status today?
Yes, Your Lordship, the case was last listed on 25/4 of 2019 before the Honorable Apex Court.
So what is the status today?
So
Thereafter, the case has not been listed, Lordship. And
Motion hearing stage.
it is in the stage of final hearing.
No, no, you show us from the court orders which are uploaded.
So, 25. Case number is SLP.
These matters are pending which have traveled from Guwahati High Court.
Yes, no, the similar matter from the Bombay High Court or the Nagpur bench. Because here,
This is an old update. You get us a present.
and you
Present
also
status.
the Government of India affidavit. is also-
Tentative date was shown as 3/5/2018. You show us the present status.
This was the last paper.
No, Dr. Rako hoiছিলে.
In the chart you've given us, it is mentioned the tentative date is 3/5/2018. What happened after that?
Last order, the last order, I don't think I got it.
Last order, actually, I have checked from the website, you also,
Hmm.
today itself, that was of 25/4/2019, it was listed. 25/4/2019. And since thereafter, not been listed.
What happened to the orders passed by the Guwahati High Court earlier?
You also from the last order, yeah, 27/4/2018, you know, the central government's affidavit was also required, directed to file the affidavit, but the central government's affidavit they have not filed till date.
Who's for the central government?
Now you're not say SCKL, you know, for Excise Department.
Can you please call him?
I have tried him over phone, but I think today he's not present in the court. I checked up to the bar and also tried over phone. Not picking up the phone now.
Can you please inform the Central Government Standing Council, DSGI? You are for the central government. Very well, find out what is the status of in these matters before the Supreme Court.
I can do
The last tentative date was shown in 2018.
And yeah, and thereafter 25/4/2019.
We'll have it on 6th. Give us the date on 6th of February.
6th of February.
My name may be from the process for the second.
Let the matters be listed on 6th when the learned counsels for the parties will apprise the court about the present status of the matters pending before the apex court as had been submitted. Stop. Let the matters be listed on 6th for placing any orders that may have been passed by the apex court. Mr. CKS Borua, learned CGC, will appear. Represents the Union of India. Names of all councils, including the learned CGC, be reflected in the cause list. Called up. It will be called up. You wait for your turn. Yes. Yes.
Lordship, that Lordship, I have submitted that minutes of meeting, Lordship. I've received this letter.
So you have submitted, but according to you, this is dropped.
Lordship.
You have to bring it on record somewhere.
No, Lordship.
Or we can record your submissions.
Lordship, Lordship.
Yes, Mr. Mehdi.
My lord, so far this my lord can submit that my lord so far is recovery it was withheld my lord. The amount my lord we withheld as part from there.
Audit objection, my lord.
They have dropped it.
No, my lord, this because of, there's a letter from the, I've seen, my lord. It was, my lord, because of this recovery, there is a withheld, my lord, that particular amount, my lord, that was settled, my lord, as per the audit report, my lord. That's why it was.
No, no, you show, did you not show him that instruction which you
Yes,
have?
Lordship, I have shown, Lordship.
It
Huh.
is written like this, my lord. So that point, the point was settled, my lord. Only because of, my lord, as per the objection, it was, my lord, the withheld the amount.
Yes, you give that instruction to us. Your letter says para has been settled
Lordship,
on the recovery of so and so.
Lordship. But that in the last, that another document, Lordship, minute of meeting, last line, Lordship.
Proposed to drop.
On the basis of replies furnished by the Tezpur University audit proposed to drop, Lordship.
17 out of the 31.
31, Lordship. There are 31 queries, Lordship, and the 17 paras dropped, and the petitioner's number is serial number 11, Lordship.
11.
11, my lord. First flag mark, my lord.
First. You bring a short affidavit. I think it is better.
Yes, Lordship can issue direction to return back the amount. Lordship.
We can do, but your if you agree, we can record your submission. There's no problem with us. This says para settled. The particulars, the reply of the university is amount of so and so recovered from terminal benefits, and the remarks is para settled.
Settled. And last portion of the, my lord, that document. Lord.
Last portion.
Last page, my lord.
Last page it says,
Lordship.
on the basis of replies furnished,
Lordship.
audit party proposed to drop or settle 17 paras out of 31.
Lordship.
So this settlement
Para is drop, Lordship.
is dropping, or is it a case of
dropping, my lord.
Because of recovery.
Compliance?
Dropping, my lord.
Sure.
Otherwise, your lordship, this Rafiq Masi para 17 and 18, your lordship. It's very clear, your lordship.
No. That is on the event they refused. That is on the event we are called upon to decide. Now, in view of the instructions which he submits, we are not called upon to decide. They have said that it has been dropped. So if it is dropped and it is to be interpreted that the amount is to be released, we'll issue a direction to them.
Instructions speak, it infers this,
We don't know, we are recording his submission.
Yes, my lord.
That it has been dropped.
Lordship, otherwise I will file one additional affidavit, Lordship, short date, Lordship, next week, Lordship.
That would be better.
Lordship.
Let that affidavit come.
Lord.
Mr. R.K. Talukdar, learned counsel appearing on behalf of Accountant General.
No, Lordship, Director General of Audit and Accounts.
Director General of Audit and
Accounts, Lordship.
Accounts submits on the basis of instructions that the query which was raised by the Director General to the Tezpur University regarding release of what?
Withheld, your lordship, retirement benefit.
Regarding the employability of the petitioner in view of non-fulfillment of the required UGC criteria, and in pursuance whereof an amount of rupees 20,77,976 has been shown to have been recovered / withheld from the terminal benefits required to be paid to the petitioner, comma. Mr. Talukdar submits that in view of the reply and the explanation furnished by the Tezpur University that no suitable candidate was available at the time of the advertisement, and consequently the petitioner being the available and suitable candidate for the post of
Audit officer, your lordship.
audit officer,
Internal audit officer.
internal audit officer, comma, he was appointed notwithstanding that he did not fulfill the required UGC criteria. Stop. In view of such reply, the Director General of Audit and Accounts has been pleased to intimate the Tezpur University that the said query has been dropped, along with other 16 queries raised. Stop. Mr. Talukdar submits that in view of the account auditor, what is that? Director General Audit, having dropped the query, there is no bar for the Tezpur University to release the payments payable to the petitioner, subject to such other dues as may be found to be outstanding. Stop. In view of such submissions made by the Learned Standing Council, we direct the Director General Audit to file an affidavit in that respect and place it before the court by the next date fixed. Mr. Porthakur, Learned Counsel for the petitioner, does not object to the appears for the petitioner, Mr. S.K. Medi for Tezpur University. Let the matter be listed again on
1st of February, my lord.
1st of February.
Yes.
All right, 1st of February. You can take back the instructions.
Lordship. Directly applies.
Yes.
Your lordship.
Yeah. Welfare, yes, ONGC.
Point. My lord, petitioner is the Association of Retired Employees, my lord, who retired, my lord, prior to 1/1/2007.
What is your claim?
My lord, actually, financial assistance, my lord, in form of, my lord, pension. They,
But are
see,
do the rules
they-
provide?
rule is not supporting, it is fact, my lord, I am not denying that.
Then
They are, my lord, they opted for CPF and certain one-time post-retirement benefit has been given. But nowadays, price has been so raised, then that was a.
no,
and
that is
then
all right.
they-
But how will the court issue a mandamus on that?
No, not exactly to pension, but court can issue a direction to give some assistance.
On
Earlier also,
what, on what basis?
my lord, earlier also the petitioner association approached this honorable court, and the honorable court was that case was closed because, my lord, they assured that there is a scheme as Asa Kiran. The annexer 56, page 56, my lord, will the court order passed by this honorable court. Annexer
Asa
I,
Kiran.
Asa Kiran. For that reason, my lord, the case was closed and the liberty was, my lord, granted.
Then what happened?
To approach this honorable court if their grievances is not fulfilled, my lord.
Then what happened?
But the Asa Kiran scheme was closed after 1 year. So they have no other option. They have to come this honorable court.
No, Asa Kiran was closed when?
Only 1 year they have been paid, my lord.
No, at the time of when the order was passed, was it pending or not?
No, at the time of, my lord, when the case was pending, the statement made by the ONGC council that there is a scheme as Asa Kiran. And on the basis of that, my lord, the case, my lord, lordship may go to the order, my lord. Paragraph 3.
No, no, we have seen it. You said that it is closed.
It is now closed, my lord. Only 1 year they have given benefit, only 1 year.
So did you not approach
So
them?
we have to come, my lord.
No, no, after this order, did you approach the authorities?
Yes, my lord, yes.
You approached?
Yes,
Where
we
is,
filed representations, my lord.
where is that?
There were several representations.
Do you have a copy of the representation?
Yeah, okay. I'm very sorry. We filed representation thereafter, my lord. 2013, we have filed representation memorandum before Prime Minister, my lord.
What is the stand of the
My
representation?
lord, only prayer, my lord, is that they are fighting for their bread and butter, my lord. The fag end of their life, and the ONGC is the one of the richest oil corporation within the my lord continent. So they can at least some financial assistance to their employee, my lord, who has, my lord, bring the ONGC to the present status, my lord. They have worked hard for ONGC. And not more members are there. 1,000 to 1,500 members are there, my lord. All are above 80 years, my lord. Take end of their life, my lord. And they, at this stage, they are praying for their life, bread and butter, my lord. And I have in paragraph, my lord.
You are not covered by pension scheme.
Yes, no.
Why?
Because at that relevant point of time, the scheme of CPA was there, my lord. Contributory Provident Fund. The amount was very small, my lord. Contribution was very small. And now price has been so much increased. How they will survive, my lord? From 2007, they have been paying pension, my lord. Prior to 2007, my lord.
When did they retire?
Prior to 2006, my 2007, my lord. 1/1/2007. Prior to 2007.
Yes.
My lord.
Sahibwala, what do you?
My lord, affidavit we have given, my lord, the various other benefits are given to them. If your lordship take up the affidavit, my lord. My lord, because whatever is applicable, my lord, that only we can give, how to otherwise we cannot. Annexure A series, my lord, is there. Page 27, your lordship may see my affidavit, my lord.
Yes.
This is a creation of a corpus in order to take care of medical or any other emergency. So retired employees of, so this is one. Now, second is, my lord, page 32, medical facility scheme for retired employees. Not that, my lord, then page 44, my lord, reimbursement of the cost of hearing.
What benefits are they getting now? Are they getting any benefits?
My lord, these are the various benefits, my lord. Page 46 also, my lord. Policy for reimbursement of the expenditure incurred by the purchaser of having respiratory devices for insurance. Various other schemes are there.
These are mostly medical.
Medical.
Mostly medical, then, my lord. Yeah, age old, my lord, they require that small. Then, we have given felicitation, my lord, of 25,000 that you'll also find at page 58. Page 58, my lord. Felicitation of retired employee aged 75 years and above. So they were given 25,000 each, my lord.
Then some ex gratia is also given, my lord, page 63. These are the various schemes which are applicable to them also, my lord.
Ex gratia for what?
Revised scheme of ex gratia for pre 59 employees and post 14 and
Page,
employees.
page number
63.
63.
This scheme comes effect from, my lord, 2003 onwards. That what will they will get, my lord, that has been given at page 65. As Gesia, my lord.
No, are they entitled to this amount?
My lord, yes. This is entitled, my lord. That is why you have given the affidavit. These are, my lord, the schemes which are applicable to them also. Then another scheme is there at page 68. This is another method. The various schemes are there, my lord, but what they are asking for, my lord, that cannot be, my lord. Some scheme, my lord, that cut-off that is fixed, that cannot be changed, my lord. And moreover, this pension is not applicable so far ONC. Supreme Court has already said, my lord. Then another scheme is there. at
Yes,
page-
are you applicable? Are these schemes applicable to you?
My, not all. Not all. My prayer lordship may kindly go through it. Repeat some prayer.
Please read.
Page, my lord,
22.
22.
Hmm.
To implement a standard liberalized pension scheme covering all the retired employees of Oil and Natural Gas Corporation Limited, computed on the minimum pay scale given effort from 2007, made applicable all persons who are getting, my lord, after 2007, my lord, pension. That is one thing, my lord. Issue of ONGCL share of rupees 4 to 10 lakhs free of cost to each retired employee in recognition of their services. Restore Golden Jubilee Award of rupees 50,000 and 15 grams gold to each retired employee of ONGC. To implement the financial aid,
On what basis are you making these claims?
my lord, these were not given to us, my lord.
No, no. Was it required to be given to you under any scheme, any law, any procedure?
Actually, my lord, they are the persons who has made the ONGC present status, my lord, who has worked
For
hard.
which you have been given the benefits?
My lord, no benefit has been given, my lord.
No, you have been given your salaries, you have been given ex gratia.
Asakiran was introduced, but that has been stopped after 1 year. And
No, but before the stoppage of Asakiran, why did you not apply for it?
we are before your lordship, my lord. We have come to this honorable court. As this honorable court stated that lordship has given us liberty to approach this honorable court. If
No,
our
but did you apply? You're not answering the query of the court. Come to page number 56. 56. 56 is the direction of the court.
court
And
petitioner is disposed of, however, it is provided that if the petitioners are still aggrieved by the aforesaid
no,
guideline,
before that, these guidelines, Asakiran guidelines, the court observed that it will take care of the grievances raised in the writ petition. After that, what happened? After this order?
that has been closed, my lord, and that's why after this order, Asakiran has been closed, my lord.
When was it closed?
My lord, 2014.
Which,
Then
which
in
date?
2015, we have come to this honorable, we made statement in this honorable court before this honorable.
Why this statement was made that Asakiran will cover when it was closed? Page number 56 of the writ petition.
Well, at that time it was implemented.
No, implementable, but if it was to be closed within 1 year, how will they apply?
No, well, other schemes are given, my lord.
No,
Other schemes are
we are
given.
referring to the order of the court. The earlier writ petition was closed on the submission given by the ONGC Council.
Correct, my lord.
That there is
At that
this.
time, it was there.
Huh.
Later on, my lord, it was closed.
So,
But time to time, new schemes are coming. Time to time, new schemes are coming, my lord.
quite right. But you see the order of the court
Yes.
that this writ petition was closed on
Yes.
the ground that the Asha Kiran guidelines will cover their grievances.
Yes.
So whether any attempt was made to look into their grievances in terms of Asha Kiran guidelines, or was it shunted out only on the ground that it was
No,
closed?
we have given other schemes, my lord. If you also see.
No, so you want to say that the statement made before the court was not a correct statement?
No, correct. At that time, it was correct, my lord.
So it was passed on 4/11/2014.
Yes, at that time, it was there.
So when was it closed?
Then said 15.
Then
They
within
said
2
15.
months, if it
I
was
don't-
closed,
My lord, statement is there, my lord.
where?
So far as Korean is concerned.
You show us some authority that in matters of this, court has the power or should issue guidelines.
Even, my lord, Golden Jubilee Cooperative to the retired employee, that has also been given, page 78 of my affiliate.
No, we are asking you only a pointed query with regard to this order, because it's an order of the court.
Yes.
Coordinate bench. On the submissions made by the standing council, the matter was closed.
My lord.
Now, after that, what happened? Did they approach? Or by the time they approached, was the scheme closed? What exactly happened? That is not clear from the pleadings, either from the writ petition or from the affidavit.
Paragraph 13, lordship.
Para 13.
Paragraph 13, page 12.
So that appears to be a statement. Why did you not? Why have you not filed? You should have filed. You should have filed an application reviving this earlier writ petition.
Yes, we approached this honorable court, my lord, in 2015.
By filing a fresh writ petition.
My lord, the court said, my lord, that you have a right to come approach this honorable court.
No, court said provided
That's
your
why-
cases are considered.
That's why we are before your lordship. Court has given us the liberty to approach this honorable if grievances are not fulfilled.
If you are aggrieved by the aforesaid guidelines, which were never been applied to in your case, on the ground that it was closed, you knew it, you accepted it. What have you done with regard to implementation of the court's order? It is an order given to you at your instance.
Yes.
Then what happened after that?
After that, this Asha Kiran has been closed, my lord. That's why, as the honorable court observed, that if our grievances are not fulfilled, then we have to come this honorable court. It was closed, then I have come.
No. It is not fulfilled by what? By the guidelines. Kindly read the order. You are given liberty if your grievances are not redressed by the guidelines. Which guidelines? Asha Kiran. Asha Kiran, according to you, is closed. So you should have come before this court reviving this writ petition, earlier writ petition.
My lord, my prayer is that the Asha Kiran may be, my lord, in prayer person, that is there, my lord, that Asha Kiran may be revived.
We can't direct them to revive. It is their scheme. How can we revive? How can we issue a direction? And on what basis are we issuing a direction? You show us the parameters that under particular circumstances, court can issue a direction. We can certainly issue a direction. The question is, should we issue a direction in the facts of this case? You are asking for, what are you asking for? You are asking for issuance of ONGC shares.
Pension, basically pension, my lord,
But one of your prayer is ONGC shares.
For financial assistance, not for anything else, my lord.
Then 15 grams of gold.
Yes, that was there in Golden Jubilee, my lord, but that has not been given to the members of the Petitioners Association.
Mr. Sahiwalla, you will have to, because you see, there is an order of the court. Court, at your instance, the matter was closed. on the submission that Asha Kiran will look, ameliorate the grievances. But their claim is that Asha Kiran is closed.
No, Asakan was 14, 15, my lord, they have been given. I have, in the affidavit, I said.
Ah.
They have said 13, 14 only, not 14, 15. Not two.
No.
Uh,
Where
so
their
when we have to file the-
where their cases considered under Asha Kiran?
My lord, yes. Well, that your lawsuit will see the reply. It was filed in 2015, my lord.
Page number?
Yes, page number, my lord, 12. Para 12.
Page number?
Page number 12, 14, para 12.
14 of
Affidavit in position.
affidavit filed by
Filed by ONC, my lord.
ONGC.
On 6, 10, 15.
Page, what is the paragraph?
Para 12. my lord.
Yes. Para 12.
Yes. With regard to a statement made in paragraph 13 of the writ petition, 7 except which are matters of record, abatements, allegations, quantia disputed and denied that the same are as stated above, the employees, retired employee prior to 1/1/2007 are not covered under the revised pension scheme in order to extend the financial assistance to such employees for taking care of their emergency needs. ONC in so and so on 8/7/2009. So and so with approval of Ministry of Petroleum introduced a scheme named Arsa Kiran. As per DP guidelines, CPSE may create corpus contributing not more than 1.5% of profit before tax to create a fund to take care of their emergency needs of retired executives or retired executives. And also those employees who are not adequately covered by the pension scheme. It is denied that financial benefits given to Asa Kiran is only for year 13-14. On the contrary of the scheme, Asa Kiran was introduced with effect from 15/10/13 until that the financial assistance was released on 13/14, 14/15 eligible benefits. So it is there, my lord. They have not said, my lord, it has closed. They say only it was given for the year 13-14. And we filed the affidavit on 15. We have said that yes, 14/15 also has been given.
So your cases have been considered under Asha Kiran.
But now they are not paying, my lord. So we are suffering.
You are suffering, so you give us a handle to give you an order. You're not covered by pension. Your schemes you have been already considered.
And this
Benefits have been paid.
are for medical ground, my lord. And the occasion.
Have you applied for this in the event of your members requiring medical help?
Yes, my lord.
You've got this
But
benefits?
only the occasion arise, then can they apply for help? Otherwise
Absolutely.
not.
Absolutely.
And now the question is that they are, my lord, suffering, my lord, and they have to fight for their bread and butter. That is
all right.
very
Bread and butter. Everyone has to fight for bread and butter.
question of natural justice. The
Natural justice.
property, my lord, are few people are alive, my lord. Most of are more than 80 years, my lord. Few people are alive, my lord. Most of them are above date. And they work hard for ONGC.
Give us some
At least they
parameters.
they can introduce a scheme for these people, my
It is for
lord.
them to do it. Can we issue a mandamus? You show us, we can do.
And
We'll issue one.
the Asakiran is, my lord, closed. The court has observed and paragraph 18, lordship may kindly.
Mr. Saiwala, can you give us what benefits you extend to retired personnel?
My
from
lord,
the
I have
ONGC?
annexed those, my lord. If you also see, besides medical,
Hmm.
This page 58 is felicitation, my lord, once time, my lord, that is 25,000 and odd, my lord, this. Then page 78 also, my lord. Then another is a page 68. There are three, my lord, besides all medical facilities, these are the three schemes, my lord, by which they are getting. Medical, my lord, in fact, they have covered fully, my lord. All sides.
Yes. We can't issue a blanket direction. We cannot. We would not. You show us that some of these benefits are there, they have not been conferred upon you, or you have been deprived of these benefits.
My lord, and there was an order passed earlier by this honorable court in another case, my lord, wherein, my lord, it is stated that all the employees retired and dead will be included beneficiary of the provisions, my lord, that I think is lordship. This is passed by this honorable court, my lord, to give benefit of the pension to all the employees retired.
But pension is not applicable in your case. It is not a case that you are amenable to a pension scheme and you have been deprived. There is no scheme when you were working at that point in time. Whatever was available was offered to you. Some benefits are still there. It is not your claim that you have been deprived of these benefits.
Yes, but
Then-
the Asakiran, which was introduced for their financial, my lord, emergency financial need, that was, my lord, closed, my lord. That can the courts, or this honorable court, and after that, to introduce a fresh new, my lord, financial scheme, financial, for financial assistance.
That we can certainly direct them to examine your claims. But if you want a mandamus, then you'll have to tell us what. Hold on.
16. How much of 9?
Yes.
27, 11, 15. It approved.
Anything you want to submit?
My lord. Paragraph 8, my lord, of my writ petition.
Yes.
There was an office memorandum
Hmm? Yes, para 8. Where is that office memorandum?
Annex A. For payment of ex gratia to the, my lord, eligible employee of IOC, my lord. This is as regard to the employees of IOC, my lord.
Even for ONGC, there is a provision. It is enclosed to the.
ONGC has not given, my lord. And other, my lord, public sector, such as Central Bank of India, all are implementing pension scheme, my lord.
You kindly come to page number 6 of the affidavit. Of the affidavit filed by respondent 2 and 3.
Yes, this is CPF, my lord.
Page number 6.
Yes,
It is a continuation of the same paragraph. There the various
scheme, my lord.
schemes are narrated, which the ONGC says the ex-employees are getting the benefits. Which of these benefits have you been deprived of? Except Asha Kiran.
Ini kamu kuat saja. Ini kamu kuat ini kan?
Itu tahu.
Itu apa terus itu? Lordship may kindly peruse Annex C of the writ petition, my lord. Memorandum submitted, my lord, before the Petroleum Ministry. My lord. Wait, what's the paragraph 13 of itu amount repeat. Only for it is stated by the petitioner that financial benefit given by the said Asakiran is only for the year 13 and 14. তাৰপিছত আমি আৰু এটা paragraph পঢ়িছো। Paragraph 18 of that.
Yes. This representation.
Annex C.
Hmm.
Paragraph, my lord, third paragraph.
Hmm. You give us these materials to pass an order. You want an order, but you are not furnishing any materials. You have left everything for the court. Hmm.
Paragraph 18, lordship may kindly peruse.
When did you retire?
Prior to 2006.
What was the scheme there, Mr. Saiwala, at the time when they retired?
My lord,
What scheme was in place?
CPF was there.
CPF.
CPF.
Yes.
From 1/1/2007, my lord, pension scheme has been introduced.
Yes, my lord, virtually, if you also see in page 18, one paragraph, my lord, page 18, the top. The aforesaid statement of facts clearly revealed that the deficiency of the said policy, the said Asa Kiran scheme provides only fringes schedule benefits and has no relation or remedy whatsoever. The basic grievance of the claim by the prisoner does not say, my lord, this scheme has been told. There is no say. I mean, our affidavit filed on 15, my lord, we have said that 14, 15 also everywhere.
Well, if you have something, you give us or we are closing it. We can't pass orders on thin air.
File an affidavit that Asakiran is not there now.
No,
And
no,
then
affidavit.
may be given a chance to
No, no, not affidavit. We don't want your affidavit. There is no dispute. They are not disputing that it is not in place. You want orders from the court that notwithstanding your retirement, because of attending facts and circumstances, whatever you want to rely on, the ONGC being the ONGC should have a scheme for benefit of the retired employees. That's your case.
That
But-
is that
but
is my prayer, my lord.
That is your prayer, but prayer is based on thin air. It can't be on thin air. It must have some basis to stand on. The pleadings does not disclose anything. So if you want to refer to some citations, authorities, even without pleadings, we can consider that.
My lord, citations, I have, my lord, one thing, my lord, Nakara case that it is saying
That-
no
that is-
discrimination.
No, that is for, that is a case where in case of there is a pension, there is a cutoff date for
Deadline,
giving
yes.
benefits to some and
Yes.
denying to others. That is not applicable. This is not your case.
My lord, another thing, High Court has passed that one case, my lord, that is our High Court order, my lord, all to give benefit all the retired dead persons. This is one case, my lord. I think it will cover, my lord.
What is the citation?
All India Executive Employees Association.
We have that. That is on a different ground. That is not for covering all employees. That is a case where the scheme was sent. That was not approved. And then, in view of a particular clause that it was never approved, it was held to be approved. This is not a case on which you can place your reliance on.
And All India, my lord, employees, they are retired also, they are getting pension, my lord.
They are getting pension because they have a scheme. You don't have a scheme. You show us some.
That is why I am before your lordship that a scheme may be introduced, maybe direction may be given to introduce a
So we
scheme
can dispose it off with a direction to consider your grievances again.
again, yes.
That we can do.
By
But
introducing a appropriate scheme for.
that we can't say. That
And
for
Satakiran is already, my lord, closed.
if you want this consideration of your representation after all these years, we can do that without making any specific statement. If you want any specific directions, you must give us the materials on the basis of which you are making a prayer. You have made a prayer, but there is no basis on which you have made a prayer. We'll keep it for 23rd. You examine and tell us finally. 23rd of January. At the request of learned counsel for the petitioner. If you do not come up, we are disposing of your matter. Disposing includes dismissing also.
Only prayer to introduce a scheme for financial assistance.
No.
Nothing is there.
No.
And
Only
assembly
prayer.
introduced and that has
At
been
the cost of repetition, we are putting you to notice. Mere prayer is not enough. You have to build up your prayer. You have to give us the basis on which you are making this prayer. Some right. You must have a right. Where is your right to come and demand? You have to demand. Where is that right? You build up.
My prayer is, my lord, is a violation of natural justice law. Some persons are getting pension.
If you want, we can dismiss it today. Or we want it.
Not 23rd, my lord.
All right, 23rd. At the request of the learned counsel for the petitioner, matter stands adjourned till 23rd of January. Mr. G.N. Sahiwala, senior counsel, assisted by MS so-and-so, appears for ONGC. 23rd.
Part heard, my lord. Part heard.
No, part heard. There's hardly any hearing. Where is the question of part heard?
Not so.
May I please, your lordship? Lordship, senior counsel, Mr. Surajit Datta is on lags in court number 10.
Here we are awaiting the affidavit of the state government and the central government, my lord. We are awaiting the affidavit because we had prayed for minimum wages since we have been deployed by the Assam police. One of the police department has filed their affidavit, but with regard to the.
You are what?
My lord, we were engaged by the Assam police to provide security to the oil wells, pipelines, and the valves of the different oil installations, my lord. The fact is admitted that we were.
Mr. Dotto is representing whom?
The Oil India, if I'm not wrong. Oil
Oil
India
India.
is only involved to the extent that they have admitted that they would pay us what is fixed by the government.
The government is not fixing
The
it.
government has fixed rupees 83 per day for us. We say we are entitled to the minimum wages.
What is the minimum wages?
Madam, that would be somewhere around 15,000 a month, madam. That minimum wages, on the last day, there was a controversy as to whether the rates fixed by the state government or the central government would be applicable to us. The Union of India and the Assam government are not coming up with the affidavits.
You are,
The last,
the rates fixed by the state government would be applicable.
whatever, they have to come up with an affidavit saying this is the
What is
position.
the,
Lordship, on 17/8/23, Lordship, the Labor Department has been made party Lordship to the IA Lordship. And we have received a communication from the Labor Department Lordship. They are saying that these employment with the present petitioner organization, these are not scheduled employment because the government is decision will come into effect only which are the schedule in case of scheduled employees or workers, Lordship.
where are your engagement letters?
My lord, Lordship will have their admission. Lordship will have at page 14 is
Yeah.
one of the engagement letters.
There's no sign, nothing. Who has issued this?
Madam, this command certificate is given by at the top, Lordship will find a seal, the Duliajan police station. And if Lordships have their affidavit in opposition was filed in an earlier round of litigation at page 22.
Page?
22, my lord. Lordship will find it page 23, para 6.
You are VDPs.
No, madam. We were originally VDPs
Ah.
who were then taken into full-time service by the Assam police to provide security. If Lordship will just read the last line of paragraph number 6. As regards the above mentioned paragraph 3 of the petition, the answering dependent states that the report by the superintendent of police, it was on the basis of the request of Oil India Limited, the members of the registered VDPs were engaged as VDP volunteers to the respective police stations to provide, now Lordship will find, full-time security service to the walls and pipelines of Oil India Limited to Dibrugarh district. Now, if Lordship will kindly have the next paragraph, while denying the correctness of the above mentioned paragraph 2, so answering dependent states that as reported initially rupees 100 per VDP per month was paid, which was later enhanced to 500 per VDP per month. However, on the repeated demands and considering all aspects, the Oil India Limited enhanced the remuneration of each VDP mentioned regarding the oil installation at the rate of rupees 83.86 per day. Now, Lordship will kindly have page 26 is the affidavit filed in an earlier round of litigation by the Oil India itself. There, Lordship would like to have
division bench of PIL pending.
prayer division bench case
Enhancement.
division bench prayer pending that is with regard to this tracking down of the VDP Act because it gives zero remuneration.
Therefore, the enhancement is dependent on that.
That VDP Act is otherwise, here the question is otherwise. Lordship would like to have page 29, para 11. Or rather, my Lordship would have page 30, para 13. Lordship would find page 30, para 13, the earlier affidavit. With regard to statement 20, paragraph 5, the repetition, dependent basis stated after receiving the representation from the petitioner for enhancement of wages and regulation, oil has informed by letter that so VDPs are selected. Lordship will find selected, regulated, and deployed by the respective police station, and oil makes request for deployment and withdrawal of VDPs from oil installations as and when required to the concerned police station. The deponent for the basic state that the mode of payment of VDPs are to the SP of the district, and oil makes payment of minimum wages at 86.80 as notified by Government of Assam for VDPs deployed in field duty at Sisagat in Dibrugarh, and that the selection and deployment of VDPs are done so by the SP concerned, and the VDPs are so selected, have no claim for permanent exhibition of any job in the oil. Our claim is not with the oil.
The claim for regularization, VDP is unfounded and without any basis. Now, if Lordship will have the annexure that they had given at page 36 of the page 36. This is what the Assam Police headquarters had given. Lordship will find the subject. Standardization of recruitment and emolument structure of VDP in all PSUs. Lordship will find. Now, from the VDPs, they pick up persons to serve in the PSUs. Their Lordship will kindly have page 37 for a moment. Page
Yes.
37. Supervision. Lordship finds the paragraph. Supervision.
Yes.
Additional SP secure the district and any other officer earmarked by district superintendent of police will be the nodal officer. Responsibility of effective supervision of duties of VDP. They next paragraph. They are to make surprise checks and at times accompany them in patrolling and regularly obtain valuable information. The paragraph next to that. The supervising staff of both the police and the PSUs to ensure that there is no absenteeism among the assigned VDP teams. Regular system of multiple roll calls along with registered be introduced, which shall be signed by the supervising staff. While on the one hand, they try to say that we are giving a voluntary service, therefore entitled to nothing. The mode of recruitment, Lordship will find, has been given by this standard operating procedure under which we are now allowed to work, and they lay down strictures regarding absenteeism and everything. So therefore, my lord, our stand is twofold. One, that we are entitled to what the minimum wages act bestows upon us, number one, and number two, going by Nihal Singh, where the petitioners therein were special police officers appointed by the police authorities to guard banks, had gone through a selection process of some.
This particular notification, what does it reflect?
My lord, this
In
reflects that,
respect of your pay
my
and
lord,
emoluments.
sir, here it says that with a view, the second paragraph at page 36, with a view to streamlining this anomaly and to adopt a uniform pay structure for the VDPs engaged in various duties of PSU, it has been proposed to fix the wages of such VDPs at rupees 100 per individual per VDP member per day at par with the home guards along with other logistic supports. Now, Lordship will kindly have page 39. At page 39, is even this 100 rupees comes down to minimum wages at the rate of 86.8. Now, the stand taken by my learned friend just now on that particular letter saying that the minimum wages act will not apply because we are not under that. But then the Oil India saying that we are entitled to the minimum wages at 86.80 as it existed then. The government saying that yes, we are giving you 86.80 for minimum wages. Can it become a fixed pay for all time to come, my lord? So therefore, my lord, I was at the very first statement of saying that we need the affidavit from the state government and the central government both.
Why?
My lord, to find out what they want to now say on an affidavit as regards my contentions in the writ petition.
What is there to say? Your grievance is against the oil and the
No, I am not against the
Home
oil as such.
Department.
I am not against the oil, my lord.
Your claim is, you see, you are conversant with the fact that your engagement was made for the purposes of guarding pipelines.
Yes. And that has continued from
whatever payments are to be made will be reimbursed by the Oil India.
by the oil. Now, this engagement started in the year 2002. This engagement has continued in the year 2024.
Yes, Home Department.
Lordship, Home Department has already filed their affidavit, Lordship. Yes, SPs of concerned districts. Only 3 districts is involved here, Lordship.
Dibrugarh, Tinsukia, Dumduma.
Dibrugarh, Tinsukia, and Sibsagar.
Sibsagar.
Yes, Lordship. Yes,
Yes.
So on last occasion, when the Labor Welfare Department has been made party, Lordship, we have accordingly communicated, Lordship. Then they are telling that.
What is the labor supposed to tell you? The rates.
Yes, Lordship.
The rates they will say.
This is
Question is whether it is payable to them or not.
Lordship,
Labor says that they are not a scheduled employee.
Yes, Lordship.
But what is the effect of that judgment of the division bench?
Upen Kumar.
Huh?
Yes, Lord.
Even under that, I am entitled.
Lordship, if this
otherwise,
be so,
Lordship-
Lordship, then the Department of Finance is
Lordship would like to see,
required.
Lordship would like to
Is
see this
required,
then.
not required. You are extracting service from somebody while you are granting periodic increase in their pay. For a certain group of people, it's a fixed amount, irrespective of the cost of living, standard of living, price rise. Then is it not for the department to take a call?
Lordship would like
For
to
the
see-
government to take a call? Either you release them
That has been.
and the Oil India is agreed to reimburse
Whatever-
whatever you pay.
Lordship.
At page 39, Lordship will find one, on the one hand, they are trying to say minimum wages is not applicable. At page 39, they are granting us the minimum wage at that point of time. Is what they try to say.
Lordship, to that effect, Lordship will file the affidavit on behalf of the Department of Labor, Lordship, as being the newly imputed respondent, Lordship.
In fact, Lordship will have page 39.
See, minimum wages from the state of Assam, they may not be applicable because that is not a scheduled employment.
Yes, Lordship.
This is not the question here. Question is, what rate are they to be paid so that it is reimbursed by Oil India? Oil India is ready to reimburse.
Lordship. Lordship, to that
Yes or
effect,
no? Then
I shall obtain further instruction and I will file the affidavit, Lordship.
you are insisting on filing an affidavit when it is not necessary. What purpose will it serve?
That
What
is
purpose
true,
will it
but
serve?
the instruction that has come to us, Lordship. Lordship may
So the
have a look
instruction
on
is what?
this,
That it
Lordship.
is not a scheduled employment.
That I may have to rebut. Or at page 21, if Lordship finds, Oil has said that we will reimburse whatever the government fixes for us. They made a statement, it is on their affidavit.
Where is Mr. Dotto?
Okay, please on light. Can you say affidavit? When?
Oil is Assam police affidavit. We did.
But labor department is out of that.
She couldn't have found it after. The Assam police some engaged to it.
This is because the government, this is because the department is perhaps anxious that department
Yes,
will be
Lordship.
now required to pay.
Lordship, I shall again, Lordship, appraise them regarding the today's proceeding, Lordship, and will get the instruction again.
At page 21, if Lordship has the Oil India's letter,
You are to give us the present rate, minimum rate.
Lordship, I understood. I shall convey them.
Mr. R. Mazumdar appears for the petitioner, MS M. Bhattacharjee for the government, and Mr. D. S. Dotto, Senior Counsel, assisted by
Swami.
MSG Swami appears for the Oil India. MS Bhattacharjee will apprise the court on the next day the minimum wages for what will be this grade 4?
Lordship.
The schedule of
according to minimum wages Act 1948, Lord.
the minimum wages for the scheduled employments under the government of Assam. The list and the rates specified by the government of Assam Labor Department be placed before the court on the next date. The list again on, tell us your date. MS K. Sharma. K. Fukan appears for
The 26 January, the second week.
respondent. Respondent number 4. Who is respondent 4? There is no respondent 4.
Lordship, 4 and 5 I am appearing. 1, 2, 4 and 5.
1, 2, 4 and 5.
Yes. Oh, one is okay. 4 is, oh, Union of India, then 5 lordship, I am appearing for 5.
1, 2, and 5.
1, 2, and 5
F1
lordship.
appears for respondent number,
And amended
Uh,
plus 31.
the Union of India.
এটা আমার লগত নাই নহয়, amended to. দিছে
List
নেকি?
again on.
এইটো।
PDC
Okay, okay, okay.
Second, sorry, not second.
Lordship on the second week, lordship,
Huh?
on the second week,
Why,
lordship.
why? Only for that information. All right, 13th,
13, yes, lordship.
13th
Yes.
February.
Published.
Deeply obliged, your lordship.
Yes, yes.
Lordship may kindly peruse the order dated 1/4/2021 prior to hearing the matter. Order dated 1/4/2021.
तुम्हारे
Yes. Yes, what is the stage now?
My lord, therefore, I have prayed.
Accountant General, what has happened?
My lord, they have filed their affidavit, but they have not annexed those documents. And they have annexed my PPO order also.
PPO has been issued.
Issued, my lord.
Then what has happened?
My lord, but the effect that is not from the date of death, my lord. It is effect that is from 2009.
Huh?
Family pension paid from 205/2009. But the husband of the petitioner died on 28/2/1988.
So why it is not given? Mr. Dhor?
So for PPS concern, we have already issued
Huh?
PPO in 2009.
No, you have issued.
As per the OM, Lordship.
Huh?
As per the OM.
What is the OM?
From at page 49 of my affidavit.
Page?
Page 49, in excess C of my.
45.
49, 49.
49. Fourth of October.
Okay.
4th of October.
4th of October, 2010. Consequent upon the decision regarding counting of past service of master workers towards pension, DCRG communicated by OM number so dated 20th May 2009, followed by OM number so dated 18/3/2010 and OM dated 3/7/2010. The Accountant General Assam ANE has raised certain points for further clarification regarding the date of effect of the pensionary benefit and basis on which the period of master roll services will be effective. To meet the above points, the government in the Pension and Public Grievances Department have clarified the matter following. The date of effect of the OM dated 25/2009 will be the date of effect, that is 25/2009, as provided in Rule 52, 25 of the Assam Financial Rule. It is further clarified that the above OM was issued in pursuance of the cabinet decision dated 01/01/2009, followed by the concurrence of the Finance EC2 department conveyed by their EO number, EO dated.
No, this is with regard to the date from which the 2009 OM will be applicable.
Yes, Lord.
The question is, the person died in 1998, 1988.
88.
Died on 28/2/1988.
88. Now you have released the pension on 2009.
2009, as
Why?
per this OM, Lord. Because we are the implementing agency, we cannot go beyond the office memorandum, Lord.
And my lord, they have released the pension only issuing notice of this honorable court. When I have reached before this honorable court, by to that they have not explained anything, my lord, in their reply.
Who is for PPG department? Pension and public grievances?
They have not filed their reply.
Yes, we have not received any instruction also. We will do that. Right.
After this, there is a judgment of the court where this was held to be, this was interfered with.
How to get the.
Yes, Mr. Bora? There is a judgment subsequently.
My lord, in Sanchita Roy's other judgment also stated that
Where is
there
the
will be
judgment?
retrospective effect.
Where is the judgment?
In Binapani's judgment last page, there is a marked portion.
That has been read down. Upheld by a division bench judgment. ইয়াৰ পিছত এটা division bench judgment আছে, একো লাগে।
Expected. It বিনা পানী কেটে।
You are supposed to apprise the court. It is going the other way around. দেখাই দিয়ক তেওঁলোকক।
And my lord, more thing to submit, my lord. In my reply, I have enforced, my lord, some amount has been paid and then it was recovered, my lord. I have enclosed my bank statement as an annexure in affidavit and reply. It was filed on 28/11/2023 common affidavit against.
All right, Tuesday, we'll take it up on Tuesday. You go through the judgment and apprise the court. Tuesday. At the request of government advocate, Mr. So-and-so, matters stands deferred till Tuesday. Tuesday would be 23rd.
Maybe Lordship, appearing on behalf of Y. Doloi Miller. Matter may be taken some other name, my lord, because my sin is due to personal inconvenience.
At the request of Mr. Your name?
S.Z. Rahman. S.Z. Rahman.
S.J. Rahman, who submits that they are giving counsel, Mr. Y. Doloi, has a personal difficulty to appear in the court today and is unable to appear in court today. Therefore, prays for accommodation. Mr. Besbora, learned counsel for the petitioner, does not object. Placed again
15th February or to be possible.
after 2 weeks.
Here in your lordship,
Hmm.
as per your lordship direction, they have reported my statement on 10/1/2024, your lord. So inquiry proceeding is already completed and let them pass the order, disciplinary authority may pass the order suspending your lordship. And the petition has already retired on 31st December 2023. Yes.
Subsistence allowance not paid.
No, that part has complied, your lordship.
Okay.
Though without any interest, your lordship. Now only the departmental proceeding.
So
And-
inquiry report?
Lordship, one final hearing needs to be done, and within the next 4 weeks, Lordship, the report will be submitted. That is my instruction.
Let,
All right, let the matter be listed on 22nd of February.
and within meantime, they will file
In the
whatever.
meantime,
order-
the petition respondents are expected to complete the inquiry proceedings initiated against the petition.
They may furnish the copy of the outcome.
In the, if they want to, they don't want to, that's a mandate of the law. We don't need to tell them, remind them. Mr. Mazumdar appears for the petitioner. 22nd. Inquiry report can be furnished only upon completion. This is not completed as yet. All right.
My information, I think inquiry part has been completed.
He says one final hearing or something is there.
Let it be. As per it.
Yes. Yes, you are praying for some adjournments.
Yes, my lord. If your lordship pleases, the matter may be fixed on 30th of January.
13th.
30th.
30.
30.
30. 30 is not possible. Then it goes to
As per
February.
your lordship's convenience.
8th of February?
Yes. 8th of February, we have outstation matter. Lord.
15 February?
In February, we will work with
15th?
15th. Yes.
1/5
My lord.
February. Yes or no?
My lord, 15th February.
Yes.
Yes.
All right. It is submitted on behalf of the petitioners that matter be deferred for today. And as agreed to by both councils, the matter is listed again for further hearing on 15th